building in our virtual intermediate or alternative process. And I think the objective is, in my mind, to do it subtly enough that it doesn't really attract a lot of attention. So just a few exit ramps along the way that suit our purposes or suit, our drafting purposes without calling attention to the fact that. So I think we also need to be modest in terms of what we try to do with it. But I think we can probably do some pretty good things based on where we were talking about our last meeting.
Time,
Yeah.
Well,
So-
some of them are already court practices.
I jotted down some
Okay.
points about how I was thinking exactly the
Yeah.
same thing.
Right.
So I sat down last
Okay.
night and worked this out. Which looks like.
It looks like intermediate.
Less subtle.
Yes,
You know what
right.
I'm saying?
Yes, right.
A
But it
lot
needs
of
to be
it,
subtle.
a lot of it isn't really gonna be in the statute.
Okay.
We can leave one for Brian.
Oh, yeah.
Shall we start with 113? That's the initiation of proceedings, and I guess yeah. It looks like you kind of started there, John.
Yeah, that's where I stayed.
Is it? Okay. Well, we got the accounting and well, but again, I guess if you get out before the accounting,
Right.
then you don't even get into
Yeah.
116. Here's Brian.
There we go.
All right, well, then forget that idea. The courts are here, so we can't do that.
What did I walk you to do?
Breakfast.
Our secret meeting.
Brian, I do have coffee.
We're just getting started, and the plan of attack here is to address the primary concerns that interest people in an intermediate probate, without actually creating a separate process, more subtly creating exit ramps and things, which sound like Multnomah County and other courts may already have, adopted for practical purposes in some cases.
Yes.
And so I think it's a matter of codifying that, not calling it an intermediate probate, but accomplishing very much the same objectives just by allowing people to get out earlier and not having to follow all the way through the process once they get in through the front door.
Yeah.
Yeah, okay. So 113.035, John,
Yes, sir.
you say applies except for PR portions.
So this is, I didn't think I think there ought to be like two procedures here. I didn't think it was.
You just violated our first rubric.
Yeah, but there's this one, and maybe we can blend them together, but
yeah.
mentally I had to separate them. So if you got a no administration needed a study, where you just need to prove a will in order to validate a trust or appointment. I looked at 113.035 is a petition for appointment of PR and probate of will. So if we kind of eliminate the appointment of personal representative part of 113.035.
Do we need to?
Well,
If
you
you
file a petition for the probate of the will.
Sure.
You notice the heirs and the devisees. You wait for objections.
Sure.
You wait for a will contest. The court admits the will, does not appoint a PR, and closes the proceeding.
At 4 months, at what point?
Whenever you want.
Okay.
If you want to wait 4 months for the will contest and then closes the proceeding. There's no need to appoint a PR because you don't have any assets to administer. But it gets the will in the court, gets it proven, gets it established as last will, allows for a will contest.
But I understand that, but just again, in trying to keep it simple, is there a downside to having the PR appointed? I mean,
Yeah.
That's what the court's concerned about.
Because, well, because then if you got no assets.
Right.
Then you gotta go
But
through.
as long as we build the exit ramps, I mean,
The bond,
no. I mean, that's a different issue. That's a different issue. I'm just talking about what's the downside?
There's nothing for a PR to do.
Well, that begs my question. What's the downside of doing it? I'm just trying to do it without. I'm trying to keep it simple.
it's like a declaratory judgment that the will is valid.
Well, but
Yeah,
that's
that's
a
all I
whole
want.
different process.
Well, and the court's gonna want somebody to be responsible.
Right, and exactly, and who's doing it?
Right.
Nobody?
But I think you can still do it. You do all these things.
I think so too.
Right.
There's nothing wrong
Right.
with it being PR. The issue is we want to get people out of having to do useless acts after the estate is open.
Right.
Yeah.
Being called a PR doesn't complicate anything for anybody, even if you don't need it.
Well, and I think what Rita was talking
But it
about
complicates the
was
statute
that
to try and create a different,
was the petition to, what is it, summarily close or something like that.
Yeah.
What
Right.
is that called, Brian, in Multnomah County? Or the counties you're familiar with?
Dismiss?
Petition to dismiss.
Yeah.
So,
Yeah, but if you dismiss a case, doesn't it have a different
Or
consequence?
terminate or
than
oh
whatever.
yeah, well, we can, yeah.
Yeah.
It seems to me I think in 035, what we need to do is acknowledge that there may be petitions filed where there are no assets.
Okay.
It happens.
Yeah, right. So that would be in, where is our statement of assets?
It's 11.
Oh, yeah, and even to the point of maybe if any,
If any,
right?
right.
If any are known to the petitioner. I mean, doesn't that just authorize you to say, I don't know of any assets? And everything else could be the same, right?
They do that all the time.
Yeah,
So if you don't get, so what do you do about a bond?
We don't give a bond.
right, so then we'll
We
get that.
don't
Let's
require a bond if they
get
say
to
there
the
are
bond
no known
statute. Let's get to the bond statute
And
next.
when do you impose a bond requirement?
When the inventory is filed, if there is an
Yeah,
inventory.
okay, all right, there's our outline. Okay, so, remember we're drafting, we're not conceptualizing, we're drafting here. So in 11, we'll say a statement to the extent and nature of the assets of the estate, if any assets are known to the petitioner. Or whatever, however you want to put that, but isn't that what we want to do there? So you
Yeah.
can just say, I don't know of any assets. If you do that, that's gonna have consequences down the line.
So maybe we make it 12 if we're trying to quietly make these changes.
I thought if any are known was pretty quiet.
Well, no,
Yeah.
we make a 113.035.12
Yeah.
that says, if there are no assets known to the petitioner,
Mhm.
because they're not a personal
Right, right,
representative
right.
yet, if there are no assets known to the petitioner, and the purpose of the petition for probate is to prove a will, exercise,
Yeah.
we could give a little laundry list, exercise power of appointment. Then the 12 could have the steps.
No, because 035 is what goes in the petition. So you wouldn't.
So that's a new
you wouldn't-
that's
you
a new
wouldn't-
section.
Or is it a section, or do we just build it into each of the elements? I mean, let's try that. Let's try it. So all you say in 11 is if any assets are known to the petitioner.
Mhm.
Then what happens next? We still need request for different that won't apply if it's a no asset, so we wouldn't say anything. Information to DSL, we're still going to do that.
Still have to prove a will.
And I'm sorry, I'm sorry, I was thinking of state administration. That's testimony of testing witnesses, that's establishing forum will contest. Preference in appointing, that should be fine. What happens next? We're getting here, we'll get 105, the bond.
Okay.
We need to have something in 105 that says if there are no assets, there's no bond required. If the petition alleges there are no assets.
And the sole purpose of the.
Well, no, not just if there's no assets, because we don't care about the purpose. Just if there's no assets, no bond.
So Brian, is
Yeah,
there
it's fine.
concern that
It's
people are
superfluous.
gonna
Yeah, to say the purpose,
just say
yeah.
there are no assets when they think there are assets?
Yeah.
Is that something that is a problem for you often? Or not now?
Yeah, I can see
It is,
manipulated.
because a lot of times, I don't know, I've just seen where judges have said, well, you don't know if there are any assets, we'll make you file a minimum bond.
Yeah, that's
And
what.
the
that's what
minimum's usually 10K.
I've
Well, why don't we
experienced
make it an affirmative statement that the petitioner alleges that there are no assets,
Right.
instead of, I don't know if there are any, that there are none.
Well, but can they ever,
Then what's the purpose of, I mean,
And
I know you
that's
guys
what I was
want to
gonna ask
state
is-
the purpose, but I think the purpose should be in there because the practitioners are gonna manipulate the heck out of it and the
Sure.
judges are gonna manipulate the heck out of it.
And what exactly is the purpose of this?
Oh, if you've got a power of appointment exercisable by will, or if you have a beneficiary designation that
Distributed as per my
distributes in
estate.
favor to the trustees of a trust created under somebody's will.
I see, okay,
It's just a piece of paper until a court says this is their will.
yeah,
That's the whole purpose of it.
that makes sense.
And I had a case just recently where there were gold bars in a safe deposit box, which of course the husband and wife treated as jointly owned. They were just gonna probate gold bars. She was the only heir, anyway. But his name was the only one on the safe deposit box. Obviously, if we did a small estate process, to get into the safe deposit box, the bank wouldn't let her take the gold bars because it's gonna be, it's more
Well
than,
over 75.
well over, that's right, well over the value. So we probated and she cleaned out the safe deposit box because theirs, and that's all there was. So that's a case where we're saying there's no probate assets, we just need to get into the safe deposit box.
But those are assets of probate though.
Well,
Maybe, depends on what's in the box.
personal property jointly owned, that's a debatable issue, I know, but nobody was looking too closely.
Yeah.
The banks insist it's just a used store facility.
Yeah,
Yeah.
okay, so,
Okay.
I do think we should say the purpose.
why?
Why? Because.
Because then you're limiting it to certain circumstances, there may be circumstances we don't anticipate.
Yeah, well, I think it should be limited because here's
Why?
what I see could happen, and I think it's totally plausible. You get in, if we're gonna issue letters, if they're gonna get letters, if they don't get letters, I don't care.
No, they get letters.
If they get letters, I care, and the reason I care if they get letters is, once you get letters, there's nothing to stop you from going around town and collecting the assets and never
Yeah.
reporting them.
Sure, we're gonna require that if the inventory shows assets, then we're gonna require a bond.
But the horse is out of the barn.
Well, but isn't that the case anyway? I mean, in any probate estate, you only know what's in the inventory if the PR puts it in the inventory.
Yeah, but the difference between any probate estate and this is that this gets summarily closed. And any probate estate, there's an inventory.
Yeah, but the
there's
accounting
transaction.
only matters if you disclose the assets to
Right.
begin with.
Right, but
So
it's,
I'm just saying, I don't think there's any more gamesmanship here than there is in any.
the difference though with that.
See, I tried to avoid this conversation by not having a PR point.
Yeah, I
Yeah,
don't think
no,
a PR should be appointed. I know.
No,
What's the purpose of the PR?
Well, but I do think there are some estates that should be able to be summarily closed.
because
What? What's
They
the-
don't have any assets.
Well, a lot of times what happens is they say, okay, well, this house belongs to, and then they find out that it's already been deeded away to
right,
somebody else.
right,
And so they just ask to summarily close it.
right.
And that happens fairly
Or
often.
you
Right.
need to waive the attorney-client privilege, the Dan Ritter radio
Yes,
example.
Yes, yeah, so I don't want to try and itemize all the various
Yeah,
purposes
okay.
there might be for a no asset probate. All of this is based on our expectation that people will follow the rules, and if they don't, then there are consequences if they get caught. But
But
I
I
don't,
do think we have to have an inventory. because
oh, I do
that's-
too.
Yeah, yeah.
I do too. I'm saying, I still like disclose the assets in the, say that there are no assets or you're not aware of any. If you do that, and then it's either a minimum bond or no bond, maybe a minimum bond. Because in any case where you're doing it to exercise a power of appointment or trust or something, there's going to be a will. So those cases.
Not really.
Well, you don't think so? Somebody who's gone to the trouble of those elements of an estate plan is not going to have a will?
But the attorney-client privilege thing,
Well,
when
you
you guys
wouldn't
in
have-
prison,
You wouldn't have
there's,
this in an intestate estate, it would have been covered.
Yeah.
Well, that's true. That's true.
We
well,
have to have a will, because the sole purpose is to prove the will.
Right.
what if you
That's
want
true.
to, what if you want to waive the attorney-client privilege, or there's some,
Yeah.
There's some intestate thing that you need to
That's
do.
true. Yeah.
Right.
okay.
File
I-
tax returns.
right? I don't think you want to limit it to
Right.
testate estates.
And we see them fairly often with intestate estates when people just want to get medical records and stuff. They
Yeah,
can't
okay, all
normally
right,
get-
all right. So then the question is, then bond, do we just say no bond? What's Multnomah County do?
It depends on the circumstances, but if we have an affirmative statement that there are no assets, and there's a statement in the petition that says why they're doing it, then we'll waive the bond.
Oh, that's
So that's
interesting.
an optional thing that would bolster your argument for no bond.
Maybe that's the new section 13 or 12, is that if there's a statement in section 11 that there are no assets, in section 12, we say that you have to say why you're probating?
That's kind of what Heather was saying.
Well, yeah, right, but that's all, yeah.
You can just state in the petition that there are no assets to be administered. And then you don't need letters, because you don't have anything to do with them.
All you're doing is saying the will is valid.
Right, but I don't think that, I
But
think
you don't
this-
want to limit it. to
I
that.
don't want to limit it because there are other things that
Right.
come up. And I think that you could add a 12 that would say,
If there are no assets,
right, but what is the purpose?
is a statement of the purpose of
Purpose
the administration.
of creating an
Yeah.
estate.
And that way, if the statute doesn't state the purpose, it doesn't list what the purposes are, but we're just asking the PR, the petitioner, to say what their purpose is. Okay,
And when the people are auditing these petitions, when they come through, they're always gonna wonder why they're probating the estate if
Okay.
there are no assets.
so let's try that. In 11, we're gonna say a statement of the extent of the nature of the assets, if any are known. In section 12, if in section 11, we say there are no assets, then the statement of the reason or the purpose for the
Purpose of
Filing the
opening the estate.
petition.
filing a petition, yeah. Okay, then we go to bonds. And I guess the question for us is, do we want a minimum bond or no bond in a no asset case?
We gotta say, because otherwise. in a lot
Well, I
of
know,
times-
what do we say? Minimum bond or no bond?
Or give the
No
court,
bond.
No
that
bond.
would be the court discretion.
It's gonna not be discretion.
Doesn't the court always have discretion?
But what
No.
Ryan is saying is if they say the purpose is to prove the will and there are no assets, then you wouldn't require a bond or multiple
Right.
wouldn't require a
Right.
bond. Is that accurate?
Yeah.
And,
It's not something that just court staff would determine, but it would go to the judge.
right. And that's an appropriate discretionary.
So,
They'd rather have a no bond requirement.
Me too.
okay, so and I think I'm
Okay,
including
no
too.
bond.
So if we say that would be in sub 2, because sub 2 already says subsection 1 does not apply if the will provides no bond. The PRs is all, and so we just add a D if the petition alleges that there are no assets.
And 113, 105.
Yeah, that's 105. So a new
Add a
sub
new one.
2D, right, and just basically if it's a no asset case.
Oh, a new 2D.
Yep.
By the way, I'm answering your questions. I've been sick for a week, but I've
That
got
was my question.
all the questions you sent me.
So the other thing is to look, if we've got, the court may waive the requirement of bond if the request states the reasons why. So this is a separate.
Yeah,
If we
right,
allege no bond.
Right, that's right, yeah.
Oh, yeah, I did.
Um,
So then, now do we want to add
almost
somewhere
there.
where it says if there is an inventory that shows assets?
Yes.
where the bond-
Yes, I
Where
think,
does that?
That's a game changer.
what,
The inventory that shows assets.
yes, right, and so do we do that in the,
Well, see,
do we do that in the inventory statute? Because it seems to me,
In 113, it gives the court authority to increase or reduce the bond or require a new bond.
yeah,
And if it was inadequate, which. would
then I
be-
think what we'll do is, let's wait till we get to inventory and then maybe refer back to 113, 115. and-
It discovers assets after the.
If the inventory, if they discover assets, they're gonna have to show them in an inventory or an amended inventory. And that's gonna trigger the bond requirement. So let's get there. So we're gonna have letters testamentary in all cases, whether we need them or not. We're gonna do information to heirs, devotees, interested persons, gotta do that.
Yeah, you gotta do that.
Gotta do that. Publication of notice, are we gonna do that in a no asset case? So then we will say, so let's remember that for when we come back to the inventory, we're gonna have to add that as another requirement if you end up filing an inventory. So we will add in 155 a subsection that says basically sub 1 does not apply, or is it sub 2? Where's 2?
Sub
Okay.
1.
Oh, yeah, sub 1, sub 1 and 2, I'm not sure how you, I guess if, no, 2 is just a notice, it includes. Anyway, you figure that out, but we'll have a
So-
section that exempts the publication if, going back to the no asset.
No publication required.
So that would maybe just be a new section.
I think so, yeah, just like we have in the bond, no bond if there's a no asset.
Right.
In 155, we'll say no publication if it's a no asset.
But if,
Then we gotta remember when we come back to the inventory, that these things are all gonna get triggered then.
but then wouldn't you just put that in sub 2?
I don't think so, because these are all sequential, right?
You would want it to be 5 in
What now?
155, 113, 155, 5. waive the requirement.
I'm not sure where, yeah, I'm not sure where,
That's where I
someone wants to
think
put
it
it.
Why don't we defer it until such time as assets are discovered?
Publication of notice.
Yeah, but you
Once
wanna
you
make-
waived it, what brings it back in?
I think that what you say is waived until the filing of the inventory.
No, because there may be no inventory filed.
No, they have to file an inventory.
You don't amend your petition, do you, if you?
No, we don't want to have to do
You don't amend
that.
the petition,
Right.
so,
Because they're appointed,
yeah.
but we do have to have an inventory.
Yes.
In every.
And now we have a
No,
notice, we're
wait.
doing a notice requirement for the inventory. so
Wait,
that was
why
already-
do we have to have an inventory if there's
Because
no
that's what-
assets?
That's what proves it to the court that there are no assets. At the petition stage.
If there's no assets, I think you would just say that in your motion to get out.
But, so then the
What's the
case
point of
that,
filing an inventory that says zero?
so in the case that Brian said, okay, we think there's a house, and then the PR goes and
Right.
finds out, nope, the house isn't owned, the house is owned by someone else.
Right.
Then the PR says, no house.
I think you file a petition, a motion to dismiss, or whatever, saying, we got no assets.
And I've seen it done both ways, where they file an amended petition that shows nothing, or I've just seen the motion to terminate.
Yeah, I think that's sufficient for the motion to terminate. But look, we're getting into ourselves. I think, we got the.
We're on the.
No
publication notice.
publication, so, in the usual case, we have 90 days now to file an inventory.
Right.
Are we gonna trigger some, and certainly if the inventory discloses assets, they're gonna have to go back and do the bond and publication. But are we saying that if they discover assets even before filing the inventory, that's gonna trigger the requirement?
How do
Immediately?
you enforce that?
Yeah, I don't know. Well, you enforce it ultimately by the inventory, I guess.
Right.
Like you would have to do it immediately at the, if you said there are no assets,
Yeah.
and then you find them 45 days later.
Right.
Why? Why
How
wouldn't
do
you
you, how
just
do you
wait until
enforce
the?
that? Yeah, that's.
Yeah, well, then that's
it's
fine,
just
because,
a
you know,
bond issue.
and-
Right.
and the-
I get that.
I mean, we're gonna give them letters anyway, so.
Well, and I can so see a client who is just doing their own thing. They got their letters and then the attorney checks in 60 days for the inventory and says, how's it
it's
going?
90 now.
I know, but you know, ahead of time, so you're not
Okay,
late.
Yeah.
And then the client says, oh yeah, I discovered, this crew brands or whatever. And then you're just like, I don't know.
Well, then maybe we need a section that says, because it might also happen after the date for filing the inventory, that's true. So we may need a section that just says, within, 30 days, in a no asset case, if there are assets discovered, then within 30 days, I say 30, I don't know, the PR must get a bond if required under that statute and must publish notice.
There's a convenient place to put it.
Where?
Where?
So 113-160 got repealed in 1969.
Oh, yeah, that's right.
We've got a number.
We can't do that.
Why? Really?
That's right there.
It can be probably 163 or something.
Is that right? Is that right? That number is gone from
Yes,
that?
it's burned.
Is that
Wow.
right? That's interesting. I didn't know that.
Yeah.
Yeah, once they repeal them, you can't.
I suppose so, because then that really creates confusion.
Yeah.
Later. Yeah, that's true.
You can
Okay, so,
modify
but I think you're right. That's the place to put it.
So in that 163,
Uh-huh.
we would be saying,
If it's a no asset case,
if.
based on the petition.
File the petition
Right.
and declare there's no assets.
Right.
The obligation to publish under 113-155 is waived.
No, that's still in 155. I think
No,
all we
I'm-
need,
oh, you
I think
said-
all we need to do 160. I think we do the waiver of the bond requirement in that statute, the waiver of the publication requirement in that statute. Then we have 163 that says if you have alleged a no asset case and you thereafter discover assets subject to administration, then within blank number of days, you need to comply with you need to comply with the bond requirement 113-105.
Bond,
And you need to commence publication under that one.
and how about notice the devisees and errors? Because if you previously told them there's nothing there, and now there's something there,
Boy, that does change the concern about contesting a will or whatever.
yeah, and then
No,
there's
that's a good
something
point.
there, you have
Yeah.
an obligation to let them know that was misinformation, and then you file the inventory. But that's where we could also say, if there really is nothing there, after so many days, you can petition the court to summarily close the matter and discharge the personal representative.
Maybe so.
That's why I wish there was some kind of way to go back to the beginning if in that case, because, you know, isn't that going to mess up all the timelines?
No, because the timeline, what do you mean?
Well, if you found
Oh,
the assets,
Right, then
you
the
know,
4 months is starting.
yeah, okay, yeah,
Yeah. because
For
the
creditors' claims,
starts
the-
with the publication.
yeah,
But the 4 months for the will contest begins,
right,
right, immediately.
Unnoticed.
Yeah.
Yeah,
so.
so we're not adjusting that.
Okay, but so you found all these assets, but now it's worth it to somebody to do the will contest, but they only have a short amount of time or no
Well,
time
yeah,
to do
and
it?
you just said we're gonna re-notify them. because
Okay, but
because
you're-
The will contest could run from the date you tell them of the discovered
Right.
assets.
But I think
that's-
Marissa's point is,
right.
somebody may not have any motive to file a will
Right, if
contest.
there's no
if it's a
assets,
no
what are
asset.
they gonna go
And
fire a
then-
lawyer to do
I
that?
need to,
Yeah.
I need to flush the will contest through in order to validate the will,
Yeah.
even if you don't have any assets.
But this is, I think your question is, does the 4 months for a will contest start over if you discover assets?
Right, right,
Just like creditors' claims.
right.
Because the
Because there's
the-
no
the
motivation to contest.
strategy would be you wait 3 months and 29 days to file a notice that, oh, we found $1 million boat in my backyard that
Right.
Donald Trump said I should be grateful that I have.
And that could encourage people to make sure that there are really no assets before they file a petition saying
That's
so.
true.
Yeah, I think it's right. You have to
Maybe the will-
re-notify and
yeah.
the time on the information to heirs and devisees starts over when they're
Yeah,
assets are
maybe so.
discovered.
So it doesn't affect the no asset case because there's truly no asset case. This is never going to happen. But in a case where you do find assets, it probably is appropriate to require a renote the 4 months, even for the will contest, to start over again. So that would all be in 163. I think
Okay.
163 has to be what happens if you discover assets. You have to file a bond, or at least you have to comply with. I think we just take.
Comply,
yeah,
yeah.
take
Comply
it-
with ORS 1.
Take it back to that, yeah.
105,
Publish notice under 165 and issue, and provide notice
To heirs and
to
devisees.
heirs and
But not to
devisees.
DH, well, and DHS
An
too.
amended notice.
Yeah.
Yeah, amended notice.
Yeah.
Although it's interesting, the notice in the first place doesn't say that there are assets,
Yeah,
or
but
or
you-
not, or
But you
not.
have to attach a copy of the petition.
But the,
Well, you actually don't.
no, you
So the
don't.
notice to heirs and devisees, you
No,
don't have to
no.
attach.
You just
a copy
have
of
to
the
tell
petition?
them that it's open.
Oh, I always do.
But in any event, even the petition then would say no assets. So this amended notice has to say that assets have been discovered. Now, wait a second, heirs and devisees don't know it's a no asset case necessarily,
That's right.
It's true.
because they haven't gotten notice about that.
Hmm.
So why are we? Let's not,
Okay,
because we didn't tell them there weren't assets to begin with.
Well, but, so the people that provide the petitions, as Heather and I do,
Well, that's your choice.
Well,
I don't.
guess what? We're changing 111 to make it that you provide the pleadings to the interested parties.
Oh, don't do that.
Yeah.
Well, you're not, we're gonna have to know.
that's our
You're gonna have to
idea.
get through the work group.
That's our
That's the
idea.
law, and people, because I think if somebody challenged it, they could be very successful. You can't defeat an interested person's right without giving them adequate notice.
But you do tell them if they want more information,
Yeah.
contact the
Yes,
lawyer.
yes, yes.
And they're all public records.
And it's all public record.
Yeah.
do people ever call you and say,
No.
what's,
Well, it's because we send them the petition.
oh.
People never call me either, though.
And I
And
sent
I
the
don't send
inventory.
Okay, well, we'll get to that when we get to it.
Okay,
So,
what's the
not
difference?
re-notify.
I don't think so.
Okay.
So what's the difference between an heir or devotee who says, it's not worth my trouble to contest this will because there are no assets, and an heir or devotee who says, it's not worth my time to contest this will because there's only 10,000 of assets here.
Right.
So having $1 doesn't
Yeah.
change.
Right, yeah, sure.
Yeah.
Yeah.
Okay. Sounds good.
Okay. So that's 113, 163. Okay, and letters, publication.
And it's a good point, because if there are, well, no, never mind.
We're all trying to get through this.
Okay, no. Okay, so 113, 160 is an important statute. Discover assets, within how many days? Is 30 days too long?
Within 30 days of the discovery?
Yeah.
That's pretty reasonable.
But you have to comply with the bond requirements?
Yeah, and then
Okay.
you just notify your client, as soon as you discover
Sure.
anything, you tell me, yeah.
All right, so within, if assets are discovered in an no asset case, then within 30 days, you comply with the bond requirements and you commence publication, and that's all you do. Okay?
Okay.
So let's go on, 165, we're not, oh wait, is 164, 113, 164, is that where we provide for this motion to terminate a no asset case?
I think it goes in, yeah, I
Where-
think it goes in 163. One is if you find assets, two is if you don't.
I'd rather have a separate statute, because I think it's two different things.
So one
Yeah.
164, termination,
Motion to terminate.
okay. Is it a motion or a petition?
I don't know, what is it, court person?
Oh, yeah.
Petition commences, well, right now, under the current statute, anything is allowed, but I think it's a motion.
I don't have.
Motion for summary
What do you have to
judgment.
notice?
Yeah.
Doesn't matter who gets noticed.
Yeah, that's, yeah, okay,
It
so
doesn't affect it.
164, we're gonna create, let's call it a motion to terminate for now. And is there a time, can you do that motion immediately? Do we care?
After 90 days, so it shortens maybe the will contest period.
And 90 days is actually kind of nice. It ties with the inventory requirements.
Now, you gotta write out the 4 months.
You do.
Sort of seems like
Before you
it's
can move to,
pretty
before you can
much-
terminate?
Well, maybe that's up to you.
Oh, maybe not. No, that's
If
okay.
you're
Because-
given notice to DHS and they know they've got their 4 months.
Yes,
How about
that's
this,
true.
John?
No, you're right. Okay, no, that's right. So that would be, you're right, John. That has to be
How much of a
after
fight
4
do you want to get
No.
in for it?
How about this? You can ask for it at the 90-day point, but when you give notice, there's a 30-day waiting period, objection period.
So that,
Well, that makes it 4 months.
we want to make it 4 months from the sending of the notice of the information to heirs and deposees and DHS.
Yeah,
That's-
yeah, that we have to preserve that 4 months.
You can let it, I guess if you don't care, you could just leave it up to the proponent to dismiss the case anytime they determine there's no assets. And if you wanna make sure your will's valid, you have to write out the contest period.
Right.
So you have to be smart enough to do that. And if you've got a case where you're not really, where you're trying to waive attorney-client privilege, for example.
Right.
Once you've done that, you don't need a proceeding anymore, so
So-
you can dismiss it.
Okay, so that's, maybe we, in 164 then, maybe we can say that a motion to terminate filed before the end of the time for filing a will contest, that does not affect the rights of any party to contest the will.
Well, maybe we do it in the alternative. One is if you're trying to prove the will, the time period is the 120 days from the notice. And the second is if you're not trying to prove the will, when the PR determines that the, reason the probate was open has been accomplished. Because then we write out the 4-month period for notice to interested persons if you need it. But if you don't need it because you're trying to get medical records, then
I think it accomplishes the same thing and just a bit easier if you just say, you can file this motion at any time. It just doesn't affect the 4 month, it just doesn't affect the rights.
Have it not take effect until the end of the 4 months.
Oh, no, I would have it take effect. I just say it doesn't, somebody can still file a will contest even if you have,
after the case is closed, they're gonna file a will contest?
I don't see the courts closing it until
Yeah.
after the 4 months.
Okay.
They wouldn't now.
okay.
What
So-
about if it was,
I mean, but what's the point? What's the harm in having this? You've
Right.
waived the privilege.
Right.
Now you just
The
put in your
notice
calendar
period
in 4 months.
for
I need to
DHS
remember to
pretty
close
much
this.
Exactly.
Fight it.
Exactly.
Yeah,
It's
okay.
just a couple more months.
4
Yeah.
months doesn't seem like that long of a time.
Right.
Does anything happen in 4 months?
Right.
Okay,
And you can allow it you can allow a motion you can have a motion that will dismiss the case at the end of the 4 months.
But why not just,
It really
hold
is.
it. I think I think Jennifer has it right. I mean, what's it matter? If you've only opened the estate just for the purpose of
Whatever.
waiving attorney-client privilege or getting medical records, you've got them. All you do is calendar, 4 months down.
Absolutely.
Yeah.
Decided.
I got to remember to file a motion to dismiss that because you're not doing anything else in the meantime. We're not inconveniencing you because you're not having to file the inventory.
Yeah.
You're not having to file the accounting. So let's just do the motion at the end of 4 months and it saves all that issue.
And the court can approve it I mean, the motion can be done in 2 months, but the court can approve it for the 4 months from the date of the mailing of the information to heirs and devotees. Is that what we're looking at?
I don't know, I wouldn't, why would you
Is this the
file it?
will contest period?
Yeah,
People do it sometimes for other things. For example, the courts won't do a distribution until the 4 months have run. And so they'll, okay, you filed your motion, but we're not gonna approve it until the 4 months have run.
But that's the 4 months from the date of publication, and we don't have a publication date.
But it's also, we also look at the notice dates for DHS and stuff too.
Okay.
Yeah.
And I think that's really what we have to look at is the notice states for DHS, because,
yeah.
and then also the will contest.
Well, see, I would just say that no motion until after the 4 months, but you're saying
But
you file
that
a
is the
motion,
4
but it's
months.
not effective until the end of 4 months.
Right.
What's the point?
Well, the court can act on it, if that's what you care about. I don't know, it doesn't matter. The court's not gonna sign the order, so you can file it at 3 months and submit your order at 4 months, and then the court's gonna look at it and say, okay, we're good to go.
I think it would be kind of unusual to say the motion may be granted after the 4 months or something.
Okay.
I can look, but it seems more.
Let's just file the motion
Okay,
after 4
file
months.
after 4 months,
Yeah, 'cause
4
you're-
months from the date of
We're not
mailing,
inconveniencing anybody.
from the later of the date of mailing of the information to heirs of devotees or DHS. Usually
Which
they're done
gives-
at the same
right.
time, but not always.
Later.
I love the ones where we get through the final accounting and then they say, then we find out that they haven't given notice to DHS.
Yeah, I've got a case where it was an accidental death, no death certificate. So we've notified everybody else, but we can't send the death certificate to DHS, so we haven't notified. So.
And
that's
maybe
one
you
where-
wait.
Well, you don't have to.
Well, and I send them, if they don't have the short form, I send them the long.
Oh, I do
form.
too. Yeah, I do too.
So Rick's gonna be all over this.
What?
He's completely protected.
Rightly so.
What? Okay,
He's
you
gonna
be
say
ready.
all these
You be ready.
scumbags that always try to cheat me.
Yeah.
That's what he-
And why does he always look at you?
Are gonna file a no
John has
asset.
clients on Medicaid, yeah.
They're gonna file a no asset estate every time. And then they're never gonna tell me they got assets.
And they're committing perjury.
What's
yeah.
the difference between
Well,
that?
here's-
What is there than filing an inventory that doesn't disclose assets? Yeah.
So here's what, that's what I.
But selling it to him and.
You tell him.
I just looked to see what I wanted to remind myself what the consequence would be. So let's say we do have a bad actor PR who gets letters, collects all the assets and just says there's
Sure,
no assets
sure.
in this probate. And then the court, at the end of the 4 months, he says, I have no assets, and the motion
Oh, yeah.
to close the case and discharge the PR, then we have that 1 year statute of limitations against the PR.
On the
Yeah.
supplemental
Yeah.
document.
So, yeah, you could just cross your fingers that you got away with fraud for 12 months. But you know, that's what other PRs do, so,
Yeah.
you know, if we go back to that, that's just the way it is.
Well, let's try it. Let's try it.
Yeah, I think that it's penalty of perjury, it's fraud on the court, regardless of whether you say there are assets in your petition or not. And so
Mhm.
it's the same.
Yeah.
Okay, so we have a new 113, 164.
So it's a motion to terminate or a motion to dismiss.
Well, if it's, but now I think the motion to terminate
Yeah, I
goes in
think that's
116,
better. Oh,
doesn't
I
it?
think it's motion to close.
Yeah, that's what, yeah.
Okay, motion to close, because it's really in lieu of a final accounting then.
right.
Motion to.
Yeah.
Yeah, so I think it goes in 116.
Because terminate
But-
and dismiss all
Wait.
bring up different things that,
Yeah,
I think
exactly.
closing's better.
Yeah,
So
so
one, it's not 160, 113, 164?
not the motion, because now that if that's gonna happen in 4 months, we shouldn't put it in,
Okay, this goes in 160.
yeah, in the chapter on initiation, yeah.
No,
So,
had
but we
closing.
will have the bond and publication business in 163.
Okay.
Okay,
Do
good.
we need to say somewhere, do we need to specifically say that there's no accounting requirement, that there's.
Oh, let's,
We're gonna
yeah,
say
well,
that
yeah,
in the
let's,
motion.
we're just gonna march on through
Well,
here.
you don't get to accounting.
Right, and
Yeah.
that's why putting the motion to terminate or close in 116
In lieu of.
is a good place to put it, so.
Yeah,
that-
right.
you know what, oh, I love fun. Okay. So then what else?
So we're still doing
motion
the
to close
inventory,
is a
but we're gonna
statement.
put
We're
if
still-
any in here too.
Pardon me?
probably. Put if all the assets, if any,
No.
in here too. In 113, 165.
Oh, okay, let's see, within 90 days.
Yeah, add
shall
if
file.
any in 113, 165, yeah.
of all property in the state that has come into possession known as the first order, if any.
Mhm.
Yeah.
Okay.
And then property discovered after inventory. That's fine. We're just saying you have to amend the inventory. 163 will also impose a separate requirement if you, oh, you haven't filed the inventory. If 163 applies, you haven't filed the inventory yet. So that's fine. We'll leave 175 as it is. Wait.
So here you go, you already get 175.
Wait, 165, you may discover assets. I think we need I think that needs, we need to do a new sub 2 there that says, if in a no asset case, assets are discovered after the 90 days.
You got 175.
Well, no, that's after you filed the inventory. You haven't filed the inventory because it's a no asset case.
All right.
But it's after 90 days now, and you've discovered assets. So after 90 days, if you discover assets in a no asset case, you haven't filed the inventory, so 175 doesn't apply.
165.
Well, yeah, 175 doesn't.
Oh,
But
right,
165
right,
says,
right.
if after 90 days you discover assets, then you file the inventory within 30 days.
Yeah, I hear what you're saying. So we gotta change 113, 175.
No, I don't think we
No?
do, no, I think 165 will do it. Because now 165 says, if there's assets, you file the inventory within 90 days. If there's no assets and assets are discovered after 90 days, then you file the inventory within 30 days.
I thought you still filed the inventory with saying no assets.
Right, that's true. Yeah, so
Do you?
so 175 is right.
Well,
Yeah,
We just add the if any in 165, so that even
Is
if
it
you,
easier to file an inventory that says I got no assets than it is to try to
yeah, you're okay, all right, so
answer questions about
then
where's
maybe
your inventory?
we need to be a little bit more explicit in
Yeah,
165
no
to say,
assets.
if there are no assets,
Say no.
that's right, so that it's clear that you still file the inventory.
Yeah.
Okay,
and then 175 applies. 'cause
yeah,
it's
then
not-
you're right, perfect, good job,
Yeah.
yep. This is fun.
and the timing matches, which is nice.
And the
We're
timing
hiring.
matches. Huh?
We're hiring.
We're hiring. Are you?
Oh my God.
Yeah.
It's an easy one.
Okay.
All the rest of these just are, they continue to apply.
Mhm.
Yeah. So the key is the inventory can say I don't have any assets.
That's right.
And you can dismiss the case anytime after 4
Yeah,
months.
once, that's right.
Yeah.
If you don't have any assets.
Right. So, but let's make sure there's nothing else along the way that we need to.
So then, and they just defer publication and notice. If
Right.
there are assets.
If there are no assets, you never do it.
And you give notices to the heirs and stuff anyhow. You gotta do that
When you close the estate.
when you open it.
Oh, when you open it, yeah.
You just don't publish notice. The inventory says I don't have anything.
Right.
And after the 4 months, you dismiss it.
Yeah.
That's simple.
And subtle.
Yeah.
Most of our-
colleagues have
Under the
figured that out.
radar. Under the radar.
Most of our colleagues should be able to figure that one out.
So, but let's walk through and make sure there's nothing else in 114, 115 that we need to just touch. Duties, and then we're in 114, 255. Duties and powers of personal representative. Anything here we need to say? Because now you are a personal representative. And I think that's important.
Well, so what happens if there are unpaid taxes and no assets?
Yeah, the personal representative can have liability, but only to the extent of the
Assets.
assets.
Yeah,
Can't have
right.
any assets.
Right,
Yeah.
Can't go liability with no assets.
right. So do we need anything? I don't think so.
If you're trying to keep it subtle, no.
Yeah, no, yeah. But
So
I,
here's the problem though, okay?
what?
Sorry to be problem finder.
All right, that's a job.
We need one of those.
If
They need
we,
more.
so if there's no assets, you don't have to file your publication of notice to interested persons.
Right.
So you don't do that, but I've had cases where
Those
the,
interested persons.
Publication
Okay.
notice.
Creditors.
Yeah,
It's
But I've had
personal, isn't it?
estates.
Is that
it's
true?
called interest.
I've had estates where that's not where the creditor got the information.
Oh, sure,
That there was a PR.
Right.
So what happens if a claim gets filed in a no asset estate? You deny the claim and then we have the claims things apply?
No, because that
No.
doesn't, if you discover assets later and.
No, her point is how do you got when a claim is filed, you have to either.
Oh, yeah, you do, allow or disallow.
Disallow. Well, you would disallow it, and you remember in a notice of disallowance, you say why you're disallowing, and you say because there are no
But
assets.
see,
Well,
that's
that's, you can't
exactly
do
what
that,
Rick
can
says.
you? Didn't
Yeah.
we say that,
Right.
didn't we say you can't, that's not a good reason to
Yeah.
disallow the claim
Right.
anymore?
You have to
Yeah.
determine, is it a valid claim?
No, I said because there are no assets, you can't say that that's a
My
reason.
claim is allowed, but.
Oh, well,
Yeah,
okay,
right.
right, that's
But
right, you
there will
can't,
be
that's
no
right, you
payment.
can't reject the,
Right.
that's right, you can't disallow the claim because of that.
So you allow the claim?
Well, you just evaluate the claim.
Maybe that's what we add to 115, that if it's a no asset case, you know, and if there are no assets, you have to say that in the notice, no.
Well, I don't think that that's gonna address Rick's problem, because he's gonna say everybody lies, and they do. And
Then we need,
fairness to
then we
Rick,
need a
they
new
do.
law that says people can't lie.
Yeah.
Oh, wait,
How is
we
that
already have
different
one.
than-
Yeah.
So,
Let's just clarify that. It's not that everybody lies. It's just that everybody he knows.
Yes.
everybody who's on public
He's got
benefits
kind of
is
a
a
cop,
liar.
he's got kind of a
Sounds
cop
like
mentality.
paranoia.
You know, when you're a cop, everybody is a, you know, a perp.
Yeah.
Yeah, that's right, yeah.
So if you have a claim and you don't disallow it because it's a legit claim,
Right.
there are no assets.
Right.
And there's nothing to pay them.
There's
It's
nothing to
summarily
pay them.
closed.
And then, do you notice them that you're summarily
You have to.
closing?
Well, you
Yeah,
have to know-
anyone
you have-
who's filed a claim, because you have to give
Yeah.
some conclusion to those things, I'm thinking about the PR's benefit. The PR needs to say, go away, there was nothing there.
Okay, here, we do need to go to the claim statute then, because here's what has to happen. If you get a claim filed in a no asset case, I think we want to affirmatively say that if this is a no asset case, you don't allow or disallow, you don't disallow based on that, but you have to give notice to the claimant that it's a no asset case.
There are no assets.
Uh-huh.
That's right, that there are no assets.
Yeah.
And if assets are thereafter discovered, then that triggers the time, well, no, not to allow or disallow, because we're not changing that.
What happens if you have some assets, if you have $10,000 of assets, but the claim is for $40,000?
Right, and it's not a priority claim.
Yeah.
115,
That's a regular probate.
135.4 says, if allowed, the claim shall be paid only to the extent of assets of the estates available for the payment of the claim pursuant to the priorities. So we
Yeah.
know that
Yeah,
we can allow them. The difficulty is that I think that the way you handle that then is at the end, when you have petitioned to close, that any creditor be given notice that there's no assets to pay the claim in accord with 135.
Any creditor with, so are
Any
we,
creditor who's made a claim.
do we have it, does the PR have a duty to allow or disallow a claim?
Yes.
Is that, okay, so then, if you get a $30,000 Visa bill and you look at it, yeah, that looks like what he spent, okay, then we'll let that go through, we're not gonna contest it,
Mhm.
but then you have to notify anybody who has an allowed claim at the closing.
I agree.
of course, as a practical matter, I would
Maybe
send them a
somebody
letter anyway.
Doesn't that
Um,
happen anyway? Like if you
Just
have
leave us
people that you
alone, there are
can't
no
pay.
assets here.
All
What
right, so
Yeah.
the situation I would worry about is, we're the PR.
Now, are you Rick now, or are you
No,
John?
I'm not Rick.
No one likes to say that.
We're talking about the other 90% of the world. So we're the PR. We think we have a no asset estate.
Yep.
We get a bogus. And we think this is a bogus claim. And we think, well, if we disallow it, then we're gonna have to go to a summary determination or a separate lawsuit,
And there's no assets to pay.
and there's nothing to bother with. And
Right.
if we allow it, then it's allowed forever.
Right.
And if somebody finds that lottery ticket that didn't get cashed in.
Yeah, right.
then I'm liable for having allowed a bogus claim.
Yeah, that's interesting.
Yeah.
Okay, so what do we
That's
do? There's a way around this. We can figure
So
it
you defer, you can notify the creditor that there are no assets.
out. Yeah.
And that action on the claim is deferred.
Yeah.
30 days after
That's a better way
175.
of
Yep.
doing it, because
Okay.
I think that's a better way.
After you got 30 days after the supplemental inventory under 175.
If any assets are found.
Yeah.
Okay, so let's look at 115. Claim.
115, 135.
Is it?
Maybe you add 136.
Let's see, oh, is it 135?
It's on page 79.
That's like John 3:16, that's on page 453.
I don't have page numbers. What are we looking at?
Yeah, 115, 135 is the normal allowance and disallowance of claims. And
So we need a separate
maybe we do a
subsection.
sub 5 of
Yeah.
that, okay.
In a no asset case, so we need to have except as provided or something in the section before. But the gist is, in a no asset case, what you're going to tell the creditor is that this is a no asset case and, well, no, we want,
There's
first of all,
just no
wait,
duty to
we want a substantive law provision that says if it's a no asset case, then the PR doesn't have an obligation to, then sub 1 does not apply. Or is it, no, sub 2 does not apply. If it's a no asset case, the notice of disallowance, no.
I think we just say the personal representative has no duty to allow or disallow the claim.
Well, so that's saying one,
But it's just clear to say the PR has no duty to allow or disallow.
yeah, because you're right, one is just about notice of disallowance.
Okay.
So no duty to allow or disallow, and if assets are discovered, then the time period for a notice of disallowance under sub 1 commences as of the date of discovery of the assets.
So that
Want
means,
to tie it to the filing of the inventory or amended inventory that shows assets, so you got a date certain that way. I mean, you can always
Well-
act on the claim earlier.
Yeah, that's true, because nobody will know when that 60 days starts to run in this case.
So if an inventory or amended inventory.
Because we're saying that you file the inventory within 30 days after you discover.
Yeah.
So yeah, that's right. Okay, upon the
so
filing.
this is within how many days of the filing of the inventory?
No,
Or
upon the filing of the inventory. It commences as of the date of filing of the
the
inventory.
time for acting on the claim.
Yeah, yeah.
Okay, commences, okay. With
So either the inventory or the amended inventory in the 175 that shows
Oh,
assets.
that's right. I mean,
Good.
that's right. Because we're going to have the inventory in all cases. So in a no asset case, let's try this again. In a no asset case, the time to allow or the time to disallow does not apply.
No, the PR has no duty. to
That's
allow
right. Yeah,
it.
right. No duty. Yeah, no duty to disallow.
If
If assets are discovered, then upon the filing of an inventory or amended inventory, because it may be either one. Yeah, you may have discovered within the 90 days.
Yeah.
Then upon the filing of an inventory or amended, although I want to make sure we don't, if you filed the inventory because you found them within the 90 days, and then you file an amended inventory because you found more assets, I want to make sure we don't start the time over again.
Well, it's got to be an inventory or amended inventory that
That
shows
first.
assets.
Yeah, that
Yeah.
first,
shows assets.
Assets in the estate.
Yeah.
somehow we got to get that in there. So
Okay.
then the time period in sub 1 applies.
So in other words, creditor files claim on 30 days and then basically there's no duty to act. Then PR files inventory on 90 days and says there's $50,000 and that triggers the 60 days
Right.
of time for
Yep.
responding. So the attorney has to be on top of the fact that, that we didn't have to deal with this claim now, but
Yep.
okay, that makes
That's
sense.
what you do in a no asset case.
Yeah. That makes sense.
And are we dealing with the fact that filing the claim isn't noticed to the PR?
Well, if
that's
they
what we've already-
have no duty to act,
We've already,
then we they don't have a duty to act until
Right.
the inventory is filed.
so what are you getting at though?
Oh, because we made that part of the statute is that filing the claim.
That's right, is not
Yeah.
noticed.
Yeah, I just,
We've already said that.
okay.
So the creditor still has to do what they have to do to perfect their claim.
Okay.
Although if you know about it, well, if you discover it, then you've got notice. Okay, all right.
So that's sub 5 of
Yeah,
130.
Then 145 triggers off of the notice of disallowance, so we're okay there. Thing of beauty. There's survival action. 305.
Actions and suits.
All causes of actions survive to the PR. So we do have survival actions in the statute. I mean, I knew I didn't know we called them that.
Oh, well, in the legal line, I guess, survival.
Oh, well, right, it's not in the statute
I
itself,
mean, it
yeah.
says survived, yeah.
Yeah. Okay, so are we to 116? And this is the accounting and
I only
distribution.
get to touch that because that's a year.
Pardon me?
You only get to touch 116, it doesn't apply until a year after.
What 116?
Chapter 116,
That's accounting and distribution?
is that what you want? Or?
Yeah, accounting.
Well, but I mean, what you want really is termination.
Right.
Now
So this is where
terminate.
this is where we put the motion to terminate.
And so you might have to actually change that heading.
Or you put it in, or you put in a special statute
Right.
ahead of
Right.
063.
So
Oh, we
maybe-
got lots of numbers.
Yeah, we could be, 116,050 or something.
So ahead of the accounting,
Yeah,
we say in an asset case at the end of 4 months, the PR can file a motion to terminate, is that what we want to call it, or close? Close, okay, without the filing of an accounting. Does that motion to close, who gets service of the motion to close? Anybody?
The interested persons.
That's what the court.
Does that go back to heirs and devisees, even in a will case at that
No,
point?
it just becomes, if it's a testamentary estate, based on our definition of interested persons, it just becomes creditors and devisees.
so it would be creditors who filed a claim.
It's the same people who get notice of it, of the final accounting and all of that.
Okay, so that's not as many people as get notice of the petition.
Right.
Okay, yeah.
Notice, sorry, say that again one more time.
At the end of 4 months,
Right.
if in a no asset case, there's still been no assets discovered, the PR files a motion to terminate. Okay, first of all, what's the motion to terminate or close? Motion to close.
Okay.
Because you're at the end of the 4 months anyway, so now you're filing a motion to close. What's the motion to close say? That basically there are still no assets? Is that,
Yeah,
yeah? Is that all you need to say?
I think you want to say that.
Have you made a
Are there no
diligence search?
assets, but they never have.
No assets, rather.
Yeah.
Yeah, no assets have been discovered.
Yeah, good point.
And okay.
We had some, but I stole them.
Here's the question.
I'm channeling.
What about the certificate of compliance, for diligent search for,
Don't want to do
We
that.
don't need
no,
that.
claimants.
We don't need that because
Don't
there's no money to pay the creditors.
Don't
Okay,
say that.
all right, so.
No tax return?
Yeah, so all you're saying is there are no assets and no assets have ever come into the knowledge or possession or control of the PR. Probably the same language, there's language in the inventory, I think, it talks about control, possession, knowledge, whatever it is, something like that, so it could be the same thing. And then, yeah, so you serve that on who?
The heirs, if it's intestate, the devisees if it's testate, and.
Well, yeah, what do we say?
it's in
Creditors,
116,093.
Yeah, I would say, that's right, the person's required, for, that, I think that would just incorporate, the person's entitled to notice of a, filing of objections, yeah.
Well, but see,
You're not giving them notice of time to file objection, or are you?
well, but if you look at 116,093B, each creditor who has not received payment
Right.
in full.
Right,
And whose claim has not otherwise been barred, I guess that would be true.
Yeah.
Their claim has not
Right.
been acted on.
so are these people getting just notice of it, or is it a notice of time for filing objections?
Well, I'm just saying that these are the people.
Right.
We don't necessarily have to refer to this statute. I'm
No,
just saying
but what
it's-
are they getting? Are they getting just, we're filing a motion to terminate, to close,
They get
period?
Well, what's the point then
Oh.
if they're not going to have an opportunity to object?
Yeah,
Well, and maybe one of them knows about an asset.
right,
that,
okay,
You know,
Well, they don't need to object because their claim will not be barred.
well, right, but before the court makes this ruling.
No, seriously, because if you just dismiss the proceeding, you're not gonna have the finality of the claims process. So you don't approve, you don't disapprove the claim's filed, there's no action taken on
but
it.
Brian's point is, yeah, why give them notice if you're not,
There's no point to it.
there's no point to it, so.
There should, I would like to see us to clean up our probate practice have motions with certificates of service. And those people who are entitled to notice should get a certificate of service on a motion, just like an ordinary civil practice.
Okay.
And just like an ordinary civil practice, they have the right to object. Now, do we need to separately say you have the right to object is the question.
In probate, I think we
always
would.
do.
Yeah, in probate, I think we would. So let's do that.
I think we just do it. It's another
20 days, just like- just like an
We're used to
accounting.
Giving these notices.
20 days, just
Yeah.
like an accounting.
Well, let's not do that there. Why would we have this be the only thing in the whole probate code that requires that?
No, it's not. I mean, accounting, you have to give notice of time for filing objections. It's there in 093. So I'm saying this is a corresponding point in the
Right,
process.
right.
It seems appropriate.
I agree. And the court's gonna want that. The court's gonna want to know. If anyone's gonna complain, now's the time.
You really did have assets. You took mom's.
We
Exactly.
always required, even on the cases now where it happens, we always require
I think
notice.
it's fair.
Yeah.
It's
Um,
easy.
So one question.
Heirs or devisees.
Do the same people who are entitled to a notice
a
under
final
093.
accounting.
Yeah,
It's the distributees or the beneficiaries of the estate.
right. And creditors whose claims.
so none of
Heirs who have filed claims.
And who have not been, yeah, right.
Which, where they're not barred because there's no action on them.
So, and then they get 20 days to file
Mhm,
objections?
mhm.
Okay.
Just like
Don't we need,
093.
we need to eliminate the requirement for the affidavit of compliance if there really are no assets. And so where's the statute that requires that? That's in
115.003.
115. 003. Oh, okay. Well, let me see. Do we need
I
to?
think that's right.
Yeah, you're right. Yeah.
We just add another number 6 that says in a no asset probate where assets are never discovered, this is not required or
Well-
something.
Wait, we do want them to, don't they have some responsibility to search for assets? You don't think so?
Well, search for assets, but this is search
No,
for
no.
creditors.
No, no, in 115.003. Let's see.
Yeah,
Diligent search for claimants, notice of
Financial
claimants.
records.
proof of compliance.
Mhm.
Yeah, so.
I
because
think
what's
we,
the point of locating creditors if you don't have any money to pay them?
well, but one, look at one. Look at one though. This little one says, should make reasonably diligent effort to investigate the financial records and affairs.
As
And-
made to identify the identity of the people who have claims.
Yeah, that's true.
They're gonna have to search the financial records to try to locate assets. That's elsewhere in
That's
that.
114.
Right.
Is it? Okay, where I want to see it.
Marshal the assets of the estate.
Where is it?
So that's probably 305, 114.305.
No, that's transactions.
265.
114.
General
260.
duties.
Collect the income
Yeah.
from.
Okay,
Yeah,
well,
settle.
under the duty to and shall collect the income from
Well, that's
property.
ink.
Yeah, what?
No, it says the income from property of the estate in possession.
Yeah, that's income.
But I think, doesn't it say marshal the assets?
Yeah.
I think that's something we all know, but I'm not sure where it's at.
Really
It does.
Well, here, 225, a personal representative has a right to and shall take possession and control of the estate of the decedent,
Mhm.
but this doesn't say they have to make any particular, but, okay, we're not, if it's a no asset case, we're not gonna impose any new requirements on them. So
Right.
I was just concerned we needed to do something.
But so
So-
going back to 115.003, we need
Right.
to add a sub 6, like we've been doing on all the other
Right.
requirements that we don't require, is if it's, if it is a no asset case, I don't know how we're gonna refer to that.
Well,
but
yeah, I think refer back to the filing, it says
of that
113.
particular statute,
Yeah.
right?
It's gotta be that there's no assets have been discovered.
And
no
That
assets.
begs the question of,
Mhm.
did you make a diligent search?
But again, this is only diligent search for creditors.
Right,
We have to do,
That's what we were talking about, 114.
No
Mhm.
asset case and no assets discovered, no requirement to comply with whatever statute, whatever part of this requires this.
I think I would do it like if the petition states that there are no assets as provided in
yeah,
the original thing where.
and no assets have since been discovered,
Yeah,
yeah.
yeah, that's how I would do it.
Then there's no duty to, where is it?
Do we need to say that in a no asset case that is, if assets, because this again, place, if no assets have been discovered, then you have to do this?
Yeah, we have to add that.
Right.
So, so no asset, or 6, there's no duty to have complied with 4, that within 60 days, the PR shall cause to be filed this affidavit of a compliance.
It's not just 4, I don't think they have to.
You don't have to do the
Any of
search.
it.
Yeah.
Okay.
Yeah.
But then if
No
you
duty
discover
to comply
assets,
with
Right.
then you have.
Then you have to comply.
5.00313.
Should that go, that doesn't go back in that other section?
No, I
where-
think it's 6, yeah.
So if you don't have any assets, there's no duty to comply with 115.003 until such time as you discover assets.
Right, and if you
Yeah,
discover
then you have
assets,
to,
then.
then you gotta find,
have
okay,
to-
who's entitled to these assets?
And then
Creditors.
the timeframe would run from the filing of the inventory or amended inventory to disclose the assets.
Well,
Because
What's
we have
the period?
what is the period though?
What is
Yeah.
the
I don't think
period?
there is a period though, is there?
It's down here, the notice to.
Oh, during the 3 months following, 3 months.
No later than 30. what is
Oh,
it?
yeah, 'cause, yeah, we
Yeah,
do
during
have
the
the
3
3
months.
yeah. So that, you could say then, if assets are discovered, the timeframes required in 113.003.1 through whatever.
Yeah, commence as
Commence
of the
as of
date
the date of the filing of the inventory or-
Or amended inventory, yeah.
3
The
months.
first one the one that first shows assets. Yeah,
Okay.
okay, fun. That's great.
This is fun.
It's-
I
it is
really-
fun.
I really
This
think
area-
it's
this area
fun.
is
I know it
Yeah.
is.
I'm
We
thinking
are
of-
almost
It's great.
It's like getting those pieces.
Ah.
in the puzzle.
What's that?
It's like getting those pieces in the puzzle.
Yeah, that's right, yeah. Or finding one on the floor.
Yeah,
Oh!
that always happens.
Okay, so then we're back at 116. This is great though. I think we're closing it, we're creating a motion to close. You file a motion to close, all I need to say is that there were no assets to begin with, none have been discovered, and you serve that with a notice of time for filing objections on the same people that are required to be served under 093.
Yep, yeah, I got
The
that.
interesting thing about 116 is the title for the chapter is accounting, distribution, and closing.
There's nothing.
And there's no, like, there's.
Well, this is closing.
What, closing? Well,
Yeah.
there is, there's the supplemental. Isn't
No,
that
but
in
it
here?
doesn't say closing anywhere.
Really?
It does say
It doesn't say
accounting,
closing.
distribution.
And again, those all caps headings are inserted by legislative council, they don't, and none of
Yeah,
them.
right.
So maybe we just have a new heading ahead of, because this is gonna be just ahead of the accounting, if the heading is closing.
Closing of the no
Summary-
assets.
Summary closing.
That's interesting. Because my order of discharge personal representative, I use my, and close the estate.
Right.
But you're right, I don't see it in the statute.
Right. Well, it does say it
It
here.
says, the order of the sheet says the estate shall summarily be closed.
Oh,
There's-
okay, she found
It says it a
it.
couple
She did a
times.
word search. She's got a computer.
Yeah, it's like- yeah.
But then we're gonna call it a motion to close, so now we'll have closing prominently,
And it's the term we use in the court all the time. It's-
Closing?
Yeah.
Yeah,
So
sometimes
you're
with
not
those,
dismissing.
we try to do
Yeah.
something that people are going to understand, like that it's going to
That's
actually
nice.
tell them what the thing
Yeah,
does,
that's
even
the
if it doesn't use the words.
So then upon the motion's been filed, the notice has been given, the time has run, and then it's a general judgment closing.
Mhm.
Is that what it is?
Mhm.
Okay, and then, all right.
Yeah,
So.
And discharge.
Oh, yeah, and discharge.
Now, order of this, I'm sorry, I'm back on closing. Order of this sheet doesn't very often apply, so I'm glad to know how close.
yeah.
So the court issues an order closing the estate.
A judgment, a
A
general
judge, I'm sorry,
judgment
yes, a
closing,
judgment, a general.
and discharging the PR. Motion, so it'll be a motion to close, and do we want to say and discharge
Yeah.
PR, or just and, okay.
You
and
gotta discharge
Yeah.
the fiduciary.
And discharge PR, general judgment closing and discharging PR.
I think that's it for the, now, John, looking at your sheet, you've still got intermediate probate here.
Yeah.
I think that's a bridge too far.
Sorry.
Then we need to go back and modify the small estate proceeding, because I just kind of said whatever on the small estate
Oh,
proceeding.
wait a minute. I don't think it's that hard.
I'm thinking intermediate probate is that hard, but I don't wanna,
No,
if
that's-
we're not gonna have an intermediate probate, then I think we need to go back and amend the small estate
Right.
proceeding.
And the courts are not gonna want an intermediate probate
No.
unless it's the same value of a small estate. I think this process accomplishes the goals that we
I do
have.
too. Well,
Which
within
process?
what we just did.
Yeah, but I mean, the problem is
Well,
you're
that's the
gonna,
no asset.
Yeah,
right,
yeah.
the problem is you're gonna have those estates where it's a $400,000 house sale, and that's all the only asset is, and that
Well,
just requires.
I thought we were working on drafting an intermediate
Well,
probate.
We gave up on that.
well, I thought we did. Yeah, I thought this was sort of but all right, I understand that. But that's sort of like, okay, that's what we're gonna get to. I don't, okay, well, let's walk through this and you persuade me that we can, I want you to picture Claudia Burton in front of the Judiciary Committee.
Rogue.
Nobody will listen.
Oh, you bet.
Where's that road?
You bet.
There are probably half the judges in the
Yeah,
state who are
yeah,
opposed to an
that's right,
intermediate state
that's
on
right.
any terms.
That's a steep
All
hill.
right, so this is just from our
That's what they
last
told me.
discussion.
Okay,
If you get into this system, then all you do is you file an inventory and it just picks up what we talked about in the wrongful death thing. Instead of an accounting, you file a status report, and then when you get to the end, you close.
That's what we were talking about, is just adding in there like a statement in lieu of an annual accounting or something like that.
Yeah, and that's all that this does.
okay.
Well,
So-
but
It looks like more.
Yeah, I know, it's long.
And
Yeah.
the problem is the courts don't want it, and I guess the extra things that you're having to do in a probate is you're having to publish notice, which costs about $150, doing the affidavit of compliance, and then you do a verified statement, which is like a trustee, just a simple
Right.
trustee report.
Right.
So this just lets you do that over a longer period of time.
Okay, walk us
You
through
don't have
this.
to- So, okay, so you look at the effects section. But the qualification we can come back to. The opening is just the same as any other probate. You file your petition, you do everything. And the consequence, if you fit into this, the exit ramps that you want are that you don't have to do any interim accountings. Just file status reports.
What's the status report?
We're still on it. There's no reason to close this.
Well, there's a status report in the conservatorship cases where you just say, here's the amount, here's a copy of a bank account, this is why it's not closed. You know, well, go ahead.
All right, so then you account to the heirs and devotees instead of accounting to the court. You can make partial distributions after the 4 months if you think you've got enough money. You can pay
Without court approval.
Yeah, without court approval. We can pay attorney's fees without court approval. You don't have to file a final account. You just get receipts and consents from all the beneficiaries to close, and you close it. Like a verified statement.
But the courts aren't gonna allow it.
Yeah, this is all the stuff the courts hate.
So here, but there is one good point that we had talked about last time when we were talking about this process, is we could create a way where interim countings are waived if all creditors and devotees agree. Because that's one of the things that's a hassle. You're trying to sell.
Basically, a statement in lieu of annual account.
Exactly, exactly. We could add that to address, I mean, it's a small part of this, but it does address a huge cost of having a regular probate when you have a simple estate.
Yeah.
And that's it, because if you just have a quick in and out and you open and close it within a year,
It's no big deal.
it's no big deal, because this is what you're really doing. You're not accounting to the court for anything after the inventory.
Right,
You're filing a verified statement.
right. Yeah, okay, no. I mean,
You're done. So this just stretches it out longer than a year.
So, Brian, channel the courts. What about a statement in lieu of an annual account?
That would be an easier sell than an entirely new process.
Yeah. That's okay, so let's,
And what's hilarious is that there are attorneys who are already filing these
really?
because they don't know.
Statement in lieu of annual account.
Yeah.
Let's try
There are a
that.
lot of noobs who do it and stuff like that.
Those are the only moving parts here.
But I mean, you've got distributions without court approval, and you've got attorney fees without court approval.
That's just not gonna fly.
I don't think so.
The courts aren't gonna.
Well, if you can close the whole estate in a year with a verified statement, then you're distributing without court. You're doing.
Well, no, you're saying what's on hand.
And the courts still blesses the fees, blesses the
Yeah,
distribution, and I just don't think the courts are gonna give that kind of authority away. But I do think there would be a chance if we could say, you know, if all of the the beneficiaries sign off and any unpaid creditor signs off, then you can have a statement in lieu of annual accounting that is, however, describe it in a
Yeah.
simplified way.
Yeah. I'm inclined to agree.
Well, that's all you need. That'll work.
Okay. I'd say let's leave the distributions out.
If we go with that, I, again, am gonna beat the dead horse. We need to go back and amend the small estate affidavit.
I agree with that. What I think we should do with the small estate affidavit is Heather had done that sample petition.
Right.
That makes them, because there are people who say, well, Mom didn't want him to have anything, so I'm not gonna list him as an heir.
Right.
We need to have them have some accountability of, I agree that these are all the heirs, and I agree that I'm gonna send these.
People don't know who heirs are.
They don't know.
Okay, all right, okay, let's stop. Let's get
Okay.
this fixed first. Statement in lieu of annual accounting. So how do we describe that? I mean, we've got the verified statement in 116.
Well, so it's just where the annual accounting.
Oh, yeah, but where's the language about the verified statement?
It's in it's 083 sub
3. No,
3.
4, isn't it?
No.
4.
Uh,
Yes.
Yes, 4.
So do we do something like that in the annual?
Well, so what I would do is each account, where it says each account must include the following, you could insert a new subsection 3 ahead of 3 and say, if the estate is not ready for final settlement, something about, they may file a statement in lieu of an annual accounting.
Well, wait a second. Could we do it let's try we just do it in 4. PR may file a statement in lieu of the final, I always say in lieu of an annual account
Oh,
and final account
yeah,
or an account. Otherwise, just maybe take out final, an account.
well,
But let's see. But I just want to see if it works. If distributees consent.
Or the testator directs.
Oh, John.
the courts aren't.
Well, it's the testator's stuff.
I hear you, but the courts, again, they've got this rogue PR, they want to have protection.
There are cases where the appellate courts have knocked down that provisions like that in wills.
Like which?
There's one that said that if there are any, this one isn't on point, but I was just reading a case yesterday where the testator said, if there's any dispute about where the assets should go, whatever the PR says is what's going to happen.
Yeah, that was
Oh,
last
yeah,
year.
well, that's a latent
Too good.
fiduciary duties anyhow, so yeah.
But but it was in there that the courts basically said, the testator can waive a bunch of things, but the court still has a responsibility to the rest of the people.
Yeah.
Yeah, and the other thing that the court said was that it was obvious what the testator intended, and that was a breach of fiduciary duty. Wasn't that the ultimate ruling, I think?
Yeah, I don't think so.
There are wills drafted all over the country that say that they direct that the estate be administered with the least amount of court provision.
Yeah, but here's where public policy prevails,
Well,
I
it's
think,
like all those
over.
Washington wills.
Yeah.
Well, you got them in
So
Texas, you got them all
Washington.
kinds of places.
Yeah, I think my mom's will in Arizona.
I think we go back to consent. Creditors consent.
Yeah, I do think it should say, instead of an accounting, I think it should say an annual or the final account, so that we clarify, this is new and different.
But the problem is that for the final account
Right,
for that to
there's probably
happen, the
some other
creditors
things in here.
have to be paid.
Yeah.
And we don't have the ability to do that yet. Because.
So maybe we need a separate 5,
I think you
separate
need a
section,
separate-
or
I think if you
4,
wanna
and this
waive
becomes
the
5.
annual accounting, the creditors need to be paid. This is, the waiver is for simple stuff.
But if they consent, let's say they
Yeah.
have a
If
gigantic
they
piece of
consent, sure.
property, they're waiting to sell it because there's environmental properties and,
And that happens a lot.
Yeah, so let's try a separate subsection on the annual account then. PR, it'll look like 4, maybe 4 becomes 5 because we need to put the annual account ahead of the final account. So PR may file a statement in lieu of an annual account, otherwise required.
It should be 3, sorry.
Yeah, 3 and push down.
I
Yeah.
think it should
Push
be
down 3 to
3,
4.
yeah,
What?
I agree.
Well, we already have a
Because
3.
The 3 is about the
Oh,
final.
yes, sorry, you need to jump up. Okay, but it will look like 4.
Yeah.
An annual account, although do we refer to an annual, maybe an account required?
It's an interim accounting, it's an interim.
A statement in lieu of annual account.
And here it is, an accounting required under sub A, 1A. That's within 60 days after the anniversary.
Right.
Or B, or an accounting required under sub 1A, B, 1A and B. Okay, that's what we're talking about. An accounting required under sub 1A and B. Can be do a statement in lieu of the accounting required under 1A and B if the distributees, other than distributees whose only distribution is a cash that will be paid. Yeah, I don't think we know that yet. So it just has to be distributees, doesn't it?
Right.
Consent in writing. If A, the distributees consent in writing. B, all creditors.
Unpaid.
Yeah, all unpaid creditors of the estate. Yeah, all well, maybe just put it all in one. If all beneficiaries or all distributees and all creditors of the unpaid creditors of the estate consent.
So you could request fees then. in this-
Yes,
Yeah.
yeah.
in this
And then, just like this, just like in 4, a statement under this subject must include the period of time covered, yes.
You need the creditors to consent if there are enough assets to satisfy all claims.
That's a good one. Some creditors are ridiculous and.
Yeah. If you got sufficient assets on hand.
But
to
then how does
satisfy
the
all
court know
claims.
that if you're not
Yeah.
providing them with any financial information?
Well,
A statement in the document.
Yeah.
But I kind of feel like, so
Some courts will take that on face value, some won't.
it's just getting so complex and stupid. There's just so much stupidity sometimes, really seriously.
yeah, what kind?
Yeah, I was gonna say, that's very philosophical.
No. Okay, I'll give you something that's sitting over at the court right now. I filed in August. Protected person died. All of the assets were TOD assets. We want to get it closed for tax reasons and because the bank who's the agent got the agency accounts keep charging fees. So we're closing a conservatorship and guardianship. Everybody's consented to the accounting.
Except Claudia.
No, I have to go and get the long-term care ombudsman's consent to my accounting.
Why?
Well, great question, Brian. Why don't you call the probate commissioner in Erie County and ask her why Claudia Burton requires that I notice the long-term care ombudsman.
All right, we're not gonna
for
solve that.
accounting.
But
So that's why
that's
I'm
a
so
guardianship.
opposed.
Yeah, that's right. Okay,
So if you have a contested claim, you're not gonna get consent.
well, then give the
Then you
accounting.
have to do it.
This is very easy. This is
Why
very
do you
easy.
have to do with accounting if, what's the purpose
If
of
anything
accounting?
that's complicated,
Yeah.
it's a regular probate.
Well, that's a knee-jerk response, but what benefit does the accounting give to the claimant and the
What does the
contested
ombudsman have to
claim?
do with that at all?
What? Oh, okay, we got.
Sorry.
Oh, yeah. Right. Okay, wait a second. Okay, so we're in this new section, you can file a statement in lieu of an account required under 1A and 1B if the distributees consent creditors. Okay, let's go back to creditors. What must the statement include? Period of time covered.
And the declaration under penalty.
Yeah.
Do you want to maybe state the amount of the assets on hand?
Yes, they have to stay with the amount of assets on hand.
And the amount of unpaid claims. Kind of like a trustee report. Well, no, but then you gotta do receipts and disbursements. We don't want to do that. Amount of assets on hand and amount of unpaid creditors. Unpaid claims.
Is that it? The period of time.
Well, sometimes the courts want, in these little simplified conservator reports, they want a copy of a bank statement that proves that the money exists as of at some point close to the end of the period. Did your court do that?
Well, if we're talking about an estate,
course, concern is
different.
different, yeah, right, it's
Yeah.
more protective.
Yeah,
It's a different thing. I don't know that they would. I mean,
Okay.
if you've got a statement of lieu, I mean, we don't require a bank statement and a statement. of
right,
lieu.
that's right, yeah, so I don't think you need it in an annual.
Yeah.
So the statement includes the period of time covered, the declaration under big D, and the
Value of assets on hand.
yeah, the value of the assets on hand. So do you want to say a description of the assets on hand?
This value.
Value, so just lump sum, or is it an itemized value, or is it
I think you just value, keep it
It's
simple.
value of the
Keep
assets
it
on hand?
simple.
Okay.
You don't want to do another inventory.
Right,
Yeah, that's true, okay, the value of the
and most of
assets
the
on
time,
hand.
it's, you know, a big asset or a bank account.
And did you already say, sorry, did you already say why it's still open?
Oh, that's a good point,
And
yeah,
that was one, yeah, I think
yeah.
Okay,
the courts are gonna wanna know.
okay, so time covered, and Marissa, I'm looking at 4B, capital A.
Yeah.
Okay, so time covered, declaration, statement of the value of the assets on hand, and
Unpaid claims.
the reason, unpaid, yeah, the statement and that should be an itemized statement, shouldn't it? Itemizing
Yeah, I
creditors?
think that's a good idea.
Let's go back to that. Unpaid creditors, we'll come back and see what that means, and the statement, the reason why the statement is
Not yet ready.
is not ready to close, yeah, there you go. So, John, you don't think you itemize the creditor's claims, and I'm not sure that you do, but all you say is, we have unpaid creditors having claims of, we've got assets of this value, period, and we have unpaid creditors' claims of this value. I guess the question is, what's the point of itemizing them? I guess it really isn't.
Some courts will care, some courts won't, and so I don't know that there's any way of fixing that.
Well, and the other thing is.
You have to file a list of unpaid claims under current law. I don't see it.
In a
I
statement of
know,
lieu
I know.
final account? No,
Well,
I
you
know.
would, under a regular
You don't have to
county,
give
you
that-
would, under a
No.
regular county,
No, you don't.
No,
You know?
you
All you have to
normally
s-
want permission to pay those before, under a regular final account.
you just pay them.
You pay them, that's for permission.
because you're obligated to pay.
So,
However, there is one court that will go through, and if there's any filed claims, they want verification
Right.
and satisfactions of all of them.
Yeah,
Right,
that's
Yeah.
right.
You know,
yeah.
Well, yeah, you get those people's attention once they've got your money. Okay, so, okay, let's
and
just
that's like wrong.
I know
stay, okay, but let's go.
Which
So-
one
so-
does that?
Clackamas.
Okay, so, but it's okay, so let's go back to this.
Great. So there's two.
So again, the statement is of the assets on hand and a statement of unpaid creditors' claims, a statement of the,
You don't need to report unpaid claims in an annual accounting.
you know, okay. So-
But the court cares about, they
Well, you
care
know,
at least to
the
know.
But
courts
John's
want to
point
be-
is if
the
you don't
courts
have-
want to be the PR.
Yeah,
But the other thing that that I'm thinking about is we want this to go through without testimony from one or more judges that are saying, well, wait, we're worried about this. Let's just.
okay, all right, okay, I think there's,
Allowed.
I think there's a balance here.
claims.
If we say you have to have creditors' consent, then I don't think we have to worry about,
The creditors don't have.
I don't want the creditors to have consent, that'll take forever. So instead of the consent, we could say, claims
yeah.
allowed and unpaid. Describe what they are. If the court wants to be the gatekeeper, the court can be the gatekeeper.
Right. So you
And
gotta,
then
you
not have
gotta
them
say,
consent, because then the court can see, well, there's $15,000 of unpaid claims and there's $250,000 of asset. And so then they don't even really, yeah, you're right, they don't have to get notice.
Okay,
or you got an estate that you can't close because you've got litigation going
Yeah,
with
yeah.
a former employee.
yeah,
Who claims
Yeah.
there was a sexual harassment.
right. Okay,
Or
all right.
an ex-spouse who claims there was a breach of the divorce agreement, and they're bringing it.
Okay, so in the
Or
accounting,
you're cleaning up real
in
property.
the accounting, we're gonna require the consent of the
Yeah,
trustees.
you got a superfund problem. How are you gonna get the consent of the?
Yeah, okay, so no, good point. So you got the consent of the distributaries, you got the statement of the declaration under penalty of perjury, you got the statement of the assets on hand.
the time period.
And, well, yeah, right, yeah, the period. And the reason why the state is not yet ready to close, is that it?
And the amount of unpaid
The amount of
claims.
unpaid
Oh.
claims.
We
Well-
don't have to itemize, because the court's gonna wanna know that,
Allowed and unpaid.
allowed and unpaid.
Okay, well, that's fine, that's easy. But we don't require credit or consent.
Right,
So let's look at the statute. Maybe there's an easier way. What are we not putting into this? And that's the
It's
disbursements.
Right,
disbursements.
oh, yeah, right. And then it's ready for closing.
Yeah, and the disbursements and the vouchers.
and the
Right.
9.160, just statements that I haven't, paid family members or whatever, made gifts.
Any other information that the personal representative considers necessary to show the condition of the affairs of the estate.
That'd be a good throw in.
So I think all we're kind of deleting the disbursements and vouchers part, that's all.
Well, and the requirement for the bank statements, and then the
Yeah,
requirement.
And the
for
asset schedule.
And the asset schedule, and also the disclosures about, I paid this person who was not a professional, and I did this with my family member.
Okay, so let's go back to.
And the
So-
narrative and
Yeah, there's
everything
stuff
else.
Was there
This
some
goes-
It's
statement
not
that
just
we
one or two
wanted
things to
to
do.
include?
Yeah, so what is it again? Okay, let's go back. Statement must include period of time covered, a declaration under penalty of perjury.
Yeah.
Statement of the total value of if you look back at 2B in the statute before, total value of the property with which the PR is chargeable
Okay.
according to the inventory, or if there was a prior statement or a prior account or statement in lieu of final account, the amount of the amount. Oh, no, you don't need that. 'Cause
Just
you're-
the assets on hand.
yeah, just the total value of the property I'm just using the language that's there. The total value of the property with which the PR is chargeable according to the inventory.
I'm not sure what that means.
Well, some of that may have been paid out, and.
Well,
Inventory's a long time ago.
I think all that,
Excuse me.
I mean, what you wanna know is how much do you have now?
yeah, I know, but I'm just trying to use the same.
Yeah, we don't have assets on hand.
We don't have.
Well,
that
you don't
section
wanna have
here.
that table. that everybody uses,
Right.
you know.
The asset
mean-
schedule.
The UTCR 9.
The total value, what chargeable according to the inventory, what does that mean?
Yeah,
Right.
Well, that gives
Oh,
the,
that
that gives the starting point for the accounting.
Uh-huh,
Right.
Yeah.
But that's not where we
We don't
are.
talk about
Right.
assets
If
on
there was a
hand.
prior account, the amount of the.
right, and that would be.
So
as
what
long
is
as you
value
say
of the assets?
the
What
total
is it?
value of the property currently on hand.
So, but what does UTCR 9.160 say about that total number? That we could use that language, because that's really where we get the total. When it tells us in the accountings, we have to include that. Let's see.
What did you say,
9.160.
That's Jennifer and Rob and I spoke, Jennifer, Rob, Sam and I.
And Rita.
Oh, and Rita.
And
Well,
Warren Barris did
The
give his
total
way
value
on
of the
it.
assets as of the last date of the current accounting period?
I don't. Oh, okay. Try that
So that's
again.
the end point.
Yeah, try that again.
The total value of the assets as of the last date of the current accounting period?
Yeah,
Oh, yeah.
yeah.
The total value,
Where'd you get that?
that's the UTCR, but,
Okay, that's good language.
all right, we'll try that.
Just so we make it clear, it's just a number, a single number.
Yes,
Not the
total value.
detail.
Right,
Yeah.
just enough.
All right, John.
And no unpaid claims?
No, I just don't worry about that because that doesn't go into accounting
Not required
anyway.
right now.
Right,
Yeah.
right. All right, John.
And that's if everybody consents
The deposit,
at the
the
beginning
beneficiaries.
of the proceeding?
No, I think they consent anytime.
Right.
You filed the consent when
You
you
get the
filed
consent from the heirs and deposees?
Yeah. They always say here is if they consent. I guess we're not saying when they have to consent.
Yeah, if they consent at the beginning of the of the entire case, then
Yeah, you file their consent.
They can always withdraw it, right?
they
Yeah.
can always object.
Oh, so, okay, so they can file a consent at the beginning and you don't have to get the consents each and every year?
We're not saying that, but,
I think you
I don't-
could.
I don't see why not.
but see you have to
I
tell
like
the
that.
court.
Actually reasonable.
Consent
So
on-
you file the
Well,
consent.
I
No,
haven't
okay.
bounced this off the judges yet. so
Yeah,
it's-
well, you file a consent that says I consent to statement in lieu of annual accounting throughout the period of administration of this estate. You file that
Yeah.
at some point.
Yeah.
And, they can always, I guess you file that, and then you just refer to that whenever you file your
Yeah.
statement in lieu of
Yeah.
final account, or
So
annual
then-
account.
And partial distributions, I guess, like you got specific bequests, $1,000 to so-and-so. Why do you need court approval for that?
Oh, John,
You just do.
you're just whittling away at this. No,
I'm trying to avoid unnecessary
Well,
work
no,
and expense.
The court,
That's one of the things that I know would get a fight.
okay, we're not gonna do it.
it's not gonna get.
So you've got to you got to kind of cover the only things, when I went through this, I couldn't find any realistic way of simplifying the opening of the estate.
No.
Right.
Everything
Yeah,
there.
I think so.
And,
Well, we have in a no asset case because you're not doing publication, and you're not doing the bond.
yeah, but in a regular probate.
Right.
You're right, right.
Probate, you can't,
No.
you
Yeah.
can't simplify opening of
No.
the estate. You've got a verified statement at the end.
Right, and now
So
we have
the
a
only
verified statement
simplifications that come in between
Yeah.
are annual accountings.
and
partial
distribution.
distributions, and attorney fee approval at the end, which,
Well, and there's,
the courts have to have that. they have
Yeah.
that, I guess.
so, and there's nothing that says that the PR and the filing of its verified annual accounting, whatever statement of annual accounting, could request attorney's fees and request partial distribution.
Well, just like you can now.
Right,
anyway.
right.
Yeah,
Right.
Yeah.
And so then do we have, now, is there a provision, do some courts require or want to approve it? Well, not all, no. Some lawyers don't get approval of annual accountings.
This
Some
was the
courts
whole listserv
won't.
conversation.
Most courts won't approve an annual accounting unless there's a request for fees to be paid out.
Unless it's accompanied by a motion.
Well,
But at least in the courts that I know of that I've worked in, there has to be a reason for it. If it's just you want the accounting approved, they won't do it.
in Marion County,
They do, yeah.
And in the
There's no provision.
Oh, do we care?
Clackamas, Washington, and Multnomah, they won't.
although I talked to one Portland lawyer who said, yeah, but the courts will allow it to be revisited even if it is approved.
I think it's true.
Which is probably
It's an
true.
order approving
Probably.
instead of a judgment,
Mhm.
Right,
unless there's attorney fees, and then,
it can be an order or a judgment for attorney fees.
yeah, but that's only as to the fees, not as to the accounting, because this was what was on the listserv the other day, is how can you make an accounting, not be provided to the devisees if you don't want to have to go back to the beginning of the inventory and account at the end.
Well, I guess this throws another wrench out there is that there's no requirement to give the annual accountings
Anybody?
to anybody.
Not yet.
Yeah.
But Jennifer and I think that,
yeah, I agree, there should be.
yeah, there should be. So you're right.
We'll define anybody.
But there's nothing in 116 or 111 that requires that, but how about ex parte contact?
If it's
Is
contested
the
case.
accounting an ex parte
That's true.
contact?
But if it's an uncontested probate and they're,
How do you know?
Well,
And that's part of the
Right.
reason why the courts won't approve them is because they haven't been given to anybody.
Yeah, let's not go there.
okay,
Let's not go there.
okay, so we don't have to worry about that.
That was my case, the Fuentes case.
Yeah.
A court approval is nothing.
Yes,
It's like-
that's right.
It's like getting advice
I know.
from the
Yep,
IRS.
yep,
And it
that's true.
should stay that way.
That's right. Yeah, so I agree. I think we're done with this. I'd like to hear what you think we need to do in the small estate
Okay,
that we haven't done already.
is everybody ready to talk about that?
Well, I'm talking about the statute.
Well, I think that we need to go to a statutory form. I know legislative.
Oh, yeah,
council-
I want to go there.
I want to go to statutory form. I think that they need to, specifically, I think that they need to talk about. there needs to
We have
be
talked
more
about a statute and
detailed
getting
form,
there and it's
Yeah.
time, so that's fine.
And we need to talk about, limiting the authority of the affiant to the assets described
Yes.
in the,
Is that not clear?
affidavit.
Is that not clear?
No, it's not. I think it needs to be different.
I think it's in there, it's obscure.
Yeah, we need to have them initial that they honestly describe who the family members are.
I don't like that in your
I do.
Well, I think if you want to take all that I
Do
think
you
it'd
have
be so much
copies,
easier
which copies do you pass
Just
out?
one,
No,
sorry.
just one, here, give
to
it
take
to,
all of that
Melissa.
out of the petition and put it into a separate oath of office that they sign under penalties of perjury and
So-
get it notarized if you want or something.
in
But
a small
I
state.
think all this initial here, initial here, initial here, it's just kind of.
But there's only
cumbersome.
one filing with the court, and the
Right.
court closes the file, and so
Well, put it into a separate document
it's
that they
attached.
sign, that they file with the petition.
I'm okay with that.
Well-
And it's almost better because it's like a checklist. Okay, here's what I'm promising, rather than it's interspersed in the whole thing.
But the benefit of having it right in the petition is
Yeah.
all interested persons know what they're required and not
Yeah.
allowed to do.
But it would be what you're saying is it
It'll
would
be
be
attached to the
attached
petition.
to the petition.
Yeah, you wanna make them swear up, blood oath and all of that stuff, that's fine, but do it in a separate oath of office thing or something.
What does the oath of office say?
All of that stuff that's the initial.
I just think we add a provision at the end, or, the affiant agrees, the affiant will do as follows, and then all of those things, all in one place, one big
Well,
paragraph.
but aren't you kind of just restating the petition then? Because,
Well, you are, but you've
Yeah, I don't-
gotta consider the people that are doing this.
well, I know, which is why I think it's probably more efficient just to have them initial it in the petition.
Kind of like they do with restraining orders. I mean, they have check boxes all down the side.
Yeah.
Right.
They have check boxes on the UTCR 2 forms.
Right, that's right.
They have initial boxes on the.
Because if you do the
UTCR
petition
as well.
and then you have then you add a checklist that says I'm doing these things, all you're doing is restating what the petition said.
Well, but you're gonna have those little things, statements, right after what the affidavit says.
One
with a
after
blank.
another?
You're gonna have, and all that John's saying is just put them at the end, where they're all listed, that here's what I promised to do. I mean,
Just
it's.
stack
to
them
me,
up
it's
you
either-
gotta-
right above the notary or something.
Right, exactly, the very last thing
Yeah,
is.
you go to the bank and they want to, you need to give the bank the petition. I don't want to give the bank all this stuff. This,
And we can move all the initials to the end of the form,
Right.
just above the.
But it's
I'm
all
having
gotta be
trouble
one
conceiving
form.
this.
It's,
I think you keep it all simple.
it's all gotta be one form.
It's gotta be one form,
Yeah.
yeah.
Take it out of the body and put it at the end, I don't have any problem.
And
What does that
It can
mean?
be two forms.
No, one form.
It can be two files simultaneously.
No, one form.
The court, anything that's gonna make the court do more, they're gonna oppose.
Do you
So-
go to the court and pick up the form and then fill it out?
Yeah,
I
you
mean,
could.
That's what they do
So-
now.
Yeah,
Yeah.
so you really probably don't want 2 forms then, because doesn't that just make everything, somebody's gonna
Well-
file one and not the other? And
And see, the
Yeah,
court,
one
what the
form.
court does is they file stamp it and they give you a certified copy
Right,
of one
right,
document.
that's right.
So it's too hard for the court to file stamps, two pieces of paper.
But why two, what's the advantage? All you're doing is saying that
adding
you're
one
doing
page.
what the petition,
The vast majority of these are done by pro se people.
Yeah.
I mean, 100 to 1. And if you give them 2, they'll just get confused between, walking a block from the court to the bank, and they'll end up giving them the wrong piece of paper. I mean, it's just,
And I sort of think it's, if you have this at the end in bold or something, people are gonna notice it more than if it's interspersed with all of these other things that they're kind of confused about anyway. If somebody's mad at somebody, they're gonna look and see, well, wait, what did they not do? Oh. right
okay,
here.
all right, so let's take,
Let me give that to a third party, and they're gonna say, well, the validity of the action taken is dependent upon your having done all these things.
Which
that
is
you
true.
swore to. No, it's not. No, it's not.
Yeah.
I'm thinking about that, John.
You take a small estate as the affidavit that you have today, and, good, bad, or indifferent, it's self-executing. You give that to the bank, there's no doubt. You put this into the bank's hands and say, well, how do I know that you haven't violated all
Yeah,
these
but we
things?
have 114 that allows you to compel them to give you the money.
okay, John's point is this, he wants a clean affidavit that doesn't raise any questions.
Yeah.
For the bank. And you want the separate form that you don't have to give to the bank, so the bank doesn't say, oh, wait, you really done that?
Well,
Have you
yeah,
really done
I mean, you give this to a bank, and you think, well, wow, if you can cheat like hell, you don't have authority.
I think that if the bank doesn't want to play ball, you have other solutions to it. But I think that the people who receive that affidavit
The other solutions are not very good ones.
need to know what the person responsible for the money is required to do.
No,
The family does.
Yeah,
Yeah, but the bank doesn't. All the bank wants to know is that they're not gonna get sued if they give this money to Brian.
Well, I think the statute allows that. It already says that.
That form confuses it.
Well, then let's just state it on the form. A third party has no duty to verify that
Yeah.
above things have been.
No, they'll
That's
say-
the beauty of letters, you know, you give
Right.
those to the bank
They
and
don't
they
need
give
to
you
worry
the
about
money
it.
and they're good.
Yeah, right.
This is a flawed process. I don't like small
So
states.
Okay,
you're just
so-
adding,
so-
you're making this a more difficult situation.
Okay, so
dealing with third parties.
let's see, just what would this, maybe it's an exhibit. Maybe it's an exhibit, and when we say that the PR delivers a copy of the certified copy, it doesn't need to include the exhibit.
No, because you can't do that with a certified copy.
Yeah, right. But let's walk,
I
let's
don't
look
think the
at,
banks are gonna complain.
let's look at section 7 of our draft, if we have it, or it's 114.525. This is what we have to have in the affidavit. What are we checklisting? What are we checkboxing?
Well,
Name and address, domicile of the deceased.
I don't have that checkbox.
No, that's right. Oh, I know. I'm
Like,
just,
where
I'm
there's
just trying.
duties to other persons.
Right. Describes, take the fair market value.
And the form, I say what that is, because fair market value is an issue in a lot of small estates.
But you can't define fair market value in the form unless you define it in the statute.
right.
It is
It's
defined in the statute.
All you're doing
In the
is.
small estate act
I
statute?
just put it in layman's terms in the form.
Well, but it has, well,
I mean, the garnishment forms are kind of like that too, that they try to put it in plain language so that people can read it, and that is in the statute.
Okay.
I think that, the real statutory language would control if there was some
Yeah.
difference.
okay. Well, I just assume that Marisa, and take, work with your form and with, LC standards
play
for
with it.
statutory forms. But let's decide this question, whether the check the box goes in the affidavit itself, or whether there is a separate filing.
I
So
like
this
it.
is a checklist regarding their affirmative duties.
Yes, they're acknowledging, they're not just signing at the bottom, they're going through each one and ticking the box.
To me, it's not very hard. You just change the statute, say you have to file the application.
Yeah.
And an oath of office in the following form.
And then
And
the
if
oath
you
of
don't file-
office has to be given to who?
File with the court.
See, I think that,
And that's, well, you don't want to give it to creditors. You don't want to give it to third parties. You give it to the beneficiaries if you want.
distributees, yeah, that's what we leave it.
Okay, and we're doing, okay. I mean, are we 100% convinced that we need the checklist anyway? Because we don't have one now.
I know,
You're signing an affidavit saying these things are all true.
yeah. but
Well,
people
because
don't
the
know what
reality
they're
is that you got a bunch of morons
All
doing this.
right, so we want to check.
90% pro se.
Yeah, and it really is a very confusing statute, I think.
Statute's terrible.
Oh,
It's a
well, we've
terrible-
discovered that as we tried to walk our way through it. And
Right.
that's why this has been harder than probate.
Yeah, exactly. When the lawyers try to do it, it's
I'll
not.
just give that to you. so
Oh.
I think that's-
So,
Is that the same thing as I
okay,
have here?
so help me
Yeah.
out, Brian, maybe,
Oh.
again, do you see it as feasible? Is it, if we do this, is oath of office? I have trouble with that, because what's your office?
That's not an oath of
You're a
office.
claiming successor. You're not an officer of the court. There's no.
Wordsmith it any way you want.
Commitment to,
I'm not sure what purpose this serves, frankly, because, we have a document now that is notarized.
Right.
They're swearing to everything
Yes,
about
I
it.
know it, and that's why
I
I
don't
want to go
know
back and
why-
ask the question.
yeah, but you know what? People, when they have to initial something, to my experience, they actually stop and look at
You
it.
think so? Isn't it kind of like terms of,
The computer thing.
that's right, yeah, click,
Check the
okay,
box.
I want to get through this. Yes, I gotta get this filed.
Are we kind of trying to get legal advice from people who aren't hiring lawyers, basically?
I don't think it's legal advice, I think it's public policy to protect.
Call it what you will, that's
Yeah.
what it is.
We
We're kind
got
of
it.
trying to inform everybody about their rights. and-
Right now, there's 34 cases open in Marion County where somebody did things wrong, a lawyer.
But do you think a check the box would have made the difference? I don't.
I think on the definition of heirs and devisees, where I see one of the biggest problems, a check the box will make a difference, because then you have to intentionally lie.
They do it anyway. They
Yeah,
do it all the
but
time.
it's one thing,
And putting a checkbox on there is not gonna change
it's
much.
one thing
When
to,
they leave their brother Bob off the
Oh, yeah,
list.
they, all the time.
Well, now,
Check.
right, now,
They know they got it.
there's a point there, you know, should the form include language that, you know, describes heir? Because it doesn't now. But then again, really? I mean, when you think about what heir is, that's,
Yeah, I fight
You know,
with
it-
attorneys about that all the time.
absolutely, it's not
the
simple.
term heir.
Yeah.
Oh,
They don't-
yeah,
they don't know
well,
what it means.
Well, I mean, but it
Oh, there
does-
are no errors.
Oh,
Like,
no,
did
that's
you
right.
look?
No, I mean, you know, it's lineal. If it's not lineal, you go to the parents. If it's not,
Right?
if the
And then it
parents,
goes to
it's,
grands.
then it goes down to nieces and nephews and great nieces and great nephews or whatever their grand.
Yeah, I'm sure he's right.
Oh, that is right. So I'm not sure how you describe heir in layman's terms in a form.
Well, what you do is you have an
See,
index at the back of the form that has definitions.
No.
Oh my gosh.
Because it would have to be the statutory
What
language,
does
which is
my-
almost
my thing
impossible.
say?
You've got it'd be a diagram.
And then probably 10,000 of these I've seen.
Yeah.
Every single one of them we looked through and we always said, okay, look, you've got the will here and it says there's Bob, Jim, Steve, and all these other people, and you say you're the only heir. But what worries me is that there are all these courts where they're not doing it.
Yeah. But man, as I think about that, heir is easy if you're talking about kids and grandkids. But once you get out that kind of,
Too bad, when they get out there, they need to go to see a lawyer.
well,
but-
So here's
if you
what-
get out of this, go see a lawyer.
Here's what the form says. I acknowledge that the above accurately and honestly describe the decedent's family members who are described in those statutes. There are no other heirs. So that means they're gonna have to go to those statutes.
No, they're not. They're
just
gonna initial it.
They're not going to.
Yeah, they are just gonna.
Let's do an owner's manual with instructions.
Yeah.
Like the ones at the DMV that everybody just piles up and throws in the trash and way out.
Yeah.
Like small estates for dummies.
I'm starting to question check the box.
Well, you know, I think maybe, I understand I must mail a copy of the will and this petition, or this whatever, to these people.
We could do away with the check the boxes and just leave the language.
Well, the language is already in the statute.
No,
In the form.
It is all in the statute.
What's that?
It is all in the statute.
Yeah, it is in the statute.
That's why I've always thought we'd better off doing it, you know, an informal probate and cutting the small estate limits in half or
No.
2/3.
it's in the
It's not
statute
gonna
for
happen.
lawyers, but it's not understandable to lay people.
Well, this is the
So we
problem
need
that
to
we
have a
got.
form that's understandable to
Well,
lay.
it's not understandable to some lawyers,
Yeah,
you know.
I mean, even this isn't understandable. Like you say,
Well,
yeah.
this is the petition for limited probate, but
yeah.
Oh, okay. Oh, sorry.
so you know,
Well, what we got, you've got the
I would be
legislature
willing
and the public.
to try this. I would be willing to, with my current small state form, to try to just simplify it and take a stab at that.
Make it a lay
Make it a
person.
lay person friendly.
No check, I'm okay, we don't think.
How are you, what do you say about heirs?
She could have figured that out. The next of kin.
Oh.
They understand that better than they do errors.
Yeah.
Yeah.
But they don't know who the next of kin is.
No, they don't understand who they are.
The people in your family, whether you like it or
Okay,
not.
well, I'll try to.
I'm the grand niece. Son doesn't deserve anything.
Yeah.
Get
What's
that all the time.
Well, they're talking about the next of kin. It's what you said. It doesn't have to be who they actually want it to
Yeah.
Yeah.
Right.
be. That's, you know, just family.
Maybe we just need to beef up the statement at the end of the affidavit.
Which
I don't know.
is, where is the statement?
I don't think, in the statute, I don't think we have anything like that. It's just, this is the affidavit, that's what it has to say. You know, a statement in capital letters that I have, you know, read each of these and I agree to perform. Well, that's as good as checking
If we don't
5
make that
boxes.
form, if we don't make that form more if we don't make it a form and make it more understandable, they're just signing what they don't understand.
Right. I think it's worth a
They're
try
gonna sign
of
whatever it
saying,
takes to get
okay,
the money
here's
out
a
of the bank so they can buy a
simplified.
truck.
Okay, I mean, what's, okay,
Some.
name, age, and domicile, post office address, of the decedent. Okay. Date, the place of
But
death.
we're gonna take out social security number.
Yes, oh, yeah, right,
Yeah,
that's
yeah,
gone,
yeah,
that's
okay.
gone. Fair market value of all property in the estate as of the filing of the affidavit.
And see, what I would do is I would say fair market value does not include debt or something like that, so that they know it's not equity, it's fair market value. If the house is worth $205,000 and only worth $100.
Okay, so that's a good thing to put in the form.
Needs
Not
to
check the box,
determine.
it's
Right.
just an explanation, fair market value. We've got a definition in
We get that all the time. from
One
attorneys, too.
14?
Is there a definition
Is
now?
there, I thought we did,
Or
we did
is
something,
it
in-
just in the
it was the
statute?
inventory statute, wasn't it? Did we do something in the
I'm not
inventory
sure
statute?
we defined
Well,
it.
but see, it says value of the estate, somewhere in there, it does
It says
say.
it doesn't include that.
Say
Right,
without regard to debts.
right. A fair market value,
But it doesn't say that in the form that the courts hand out.
In determining fair market value under this section, which is this is the small estate statute, yeah.
Oh, it is,
The
okay.
fair market value of the entire interest of the property included in the state shall be used without reduction for liens or other debts.
Where's that, where's
it's
that?
114.1515 sub 5.
Yeah.
It's right here.
Okay,
Yeah.
So you're right to be using that statute, that's a. fair
yeah, okay. So in our statutory form, we could include a parenthetical there that fair market value does not include just in the statutory language. So that's helpful. Let's go on through.
Okay.
That's helpful. That goes in our statutory form. So far, everything else is self-explanatory. That no PR has been appointed and there's no pending petition. That's self-explanatory. Whether the decedent died testate or intestate.
With a will or without a will.
They signed.
That's not really that
Because some people
simple.
make that copy of the will, that's a will.
Yeah,
Oh, yeah,
like
yeah.
I wrote
Same
it
with
down
whether
on
the
my
decedent left a
cocktail
will.
napkin and with no witnesses.
A valid will. So, state whether the
Can't you say
decedent.
that? 'Cause the court determines.
Yeah. Dead, died, testate or intestate. In a
Well,
pre-
maybe you say an signed
The decedent
original.
died I put, the decedent died testate with a will.
Well, that's redundant.
There's no reason to use.
I know
the
it's
word-
redundant, but
There's
that's
no
what-
reason to use the word testing.
Yeah,
Because if
No
they-
laugh.
if they
A
have
copy of the
if they have a
will,
will, they're
the
actually.
decedent, a copy of the original will, the decedent signed is filed contemporaneously.
How about
Okay.
if the
Oh,
the
that's too
estate,
many
the
syllables.
decedent's
Yeah.
estate is subject to a will?
all those
Subject
in a row.
I don't know, like.
If you
No,
bring
no,
out
wait a second, wait a second.
a
If
will
we
is
say,
determined.
what do we say, where is it, where if the affidavit, if there's a will,
Yeah, we have that right there.
no, let's see.
There's a will attached, and if there isn't one,
Yeah,
say
right,
there
right.
isn't one.
Have we looked
Right,
at the current versions that are out there?
That's what he's looking at.
Is there a
Oh,
will?
the
If so,
forms.
attach it.
Oh, the forms.
Yeah.
Let's see.
if the decedent died with a
Here, I've
will
got it right here.
or
No, the
without.
ones that are being used right now.
Except, should the statute still say,
Well, I think
This
if
is
we're trying to
mine.
make a simplified
Mine.
form, then.
No,
we
no, I
need
mean
to
the ones
use
that the
simplified
courts are
words,
using
like
right
what
now.
you talked about the cars and stuff.
Well, this one does have definitions that apply to the process. This
Is it
little-
a separate?
It's a separate, yes, this is instructions.
Whose did you pull up?
Let's see, this is just courts.oregon.gov.
Okay.
I don't know, this might, I don't know if it, can you tell where that comes from?
Mm-mm.
Oh, Clatsop County,
Okay, well, I've never looked at theirs.
Fine County.
Oh, interesting, the Clatsop has one.
Almost every court does.
I don't think Book County does.
I
Maybe
think
they do. I
A
don't
small,
know.
a small state
I
form.
just don't use it.
Almost all of them do.
Really?
Yeah.
Okay. Well, do we want to then,
Oh, here it says, to file a small estates affidavit, you will need the following. Affidavit of claiming successor, testate if there is a will, intestate if there is no will.
is that's just the cover sheet?
This
Is the instructions.
Well, that's what I mean.
Yes, this is Washington County.
Well, maybe we need to look at that and not make it part of
and
the.
Clackamas has
Well-
one, Moldoma has one, they all have.
So, but is that part of the statute then?
No, I don't
Yeah, I don't
think
I
so.
think that would be part of the statute.
I don't know, go take a look at, if you take a look at chapter 18 where all the garnishment forms are, you kind of get an idea of how they've done it. Because there's a lot of instruction in there. You know, they'll say, you know,
Oh, garnishment is so complicated.
It is, it's terrible.
Good grief.
yeah, I mean, the forms go on forever, but you know, it says, as a garnishee, you need to know the following. This person who is called the debtor owes money to this person who is called the creditor. I mean, it's pretty,
Pretty simple.
yeah.
It's because it's so pro se. I mean, that it makes sense to do that
Right.
for the public.
Yeah.
And I get that we don't want to, but
I think rather than check the box, I think and explanatory, but do we put that in the statute?
No, I don't know.
Form, but
I mean,
the
you
garnishment
could.
forms
This
are in
has
there.
instructions
Well, that's
to the garnish
true.
sheet. It
Yeah,
has a
maybe
whole-
that's it.
Yeah.
Let's create an instructions to affiant
Yeah.
and,
That's a good idea.
okay, so
And that
let,
way all the courts are the same.
so instructions to affiant.
Yeah.
Now, do you want to just take a stab at that, knowing
Do I?
our predilections?
I mean, I can, but
Yeah.
Jennifer seems like she's into form
Oh.
creation.
This company is-
I'm
Oh,
certainly
my
happy to do it if you
bad.
don't want me.
We'll tell you later.
She's talking about the commission.
I'll do it and then I'll send it to you.
I actually think you'd be better at it since you know the ins and
Okay,
outs of
But-
it.
so
You know all the
you-
stupid
you
things that
will-
people have tried to
It will be an
do.
explanation of some of these terms,
Right.
and take a look at, what's that, I
Yeah,
like
it's
that.
18,
That's
I mean,
18.
there's a whole bunch of forms in a row.
No,
Oh,
this is
what?
the court that you were looking
Oh,
at.
that was Washington County.
Yeah,
If you Google, what did I Google here? Small estate form, Oregon, I
When I Googled it, Clackamas
think.
came
Small
up.
estate form, Oregon.
Clackamas is the most heavily used one.
Yeah, well, the state has it on their website. I don't know if you noticed that.
I know, because
That's why Clackamas is came up, because they have all the.
so, okay, you want to take it, that'll be your assignment.
it's my form, and then
Oh, right.
all of the
Yeah.
other counties asked for it. No, it's old. It's dated, so I'm not saying it's a
But
good one, but
That's comprehensive.
It's a starting place for somebody who knows what they're talking
Right.
about.
And so
So-
Clackamas County is the one to start with.
But take a look at Washington too.
Well,
sounds like-
You like Washington.
it's the one that the state's been using.
I mean, it's on the state's
But
website.
Multnomah has one too, and so
You
does
go- you go-
Washington,
Okay.
and there may be better
All right.
versions out there. Because I made that one like 10 years
Is it,
ago.
is it,
so
is it a small estate form, or is it a check, or is it an
It's a-
instruction sheet?
both.
So they have,
Okay.
yeah, it's right here. It says everything.
What they did, I was thinking this kind of same thing, but what they did with the advanced directive
Right.
revision, which turned into a real.
Oh, yeah, I'm trying to avoid, I'm trying to get all mine done before January
Oh,
1st.
So they appointed a group. to
Yes,
monitor
yes, right.
And promulgate review forms. and
Yeah,
stuff.
yeah.
So if we had some mechanism to do something like that, I
Bring
don't
them
know
up.
who would do it, but have
Bring them
somebody
up.
that would adopt, that would have some group or entity that would create
I think we just-
instructions that would be used statewide.
I think we use the garnishing example.
Yeah, okay. So, so the form, there will not be a check the box form, but we will have an instruction sheet
Is
that,
the instruction sheet in the statute?
It
yes,
is in this, in 18.
like it is in the garnishment statute. And it will just be a cover sheet to the, or how is
Well,
that?
it may just be part of the affidavit.
Yeah,
I don't know how, I'll look at the garnishment thing. Can you give me a 18?
Maybe a
18, let's see,
certification
it
that they've
starts
read it and
with-
understand it,
yeah,
read through it.
yeah.
I mean, 8:30 is where it all
Okay,
starts.
I'll just.
Hey, you can put that in the affidavit, and say, I certify that.
Oh,
I read the
838
instruction sheet.
is
Right,
instructions.
sure.
And then that doesn't
Right,
create
the-
any.
that's right.
Just
The
third
affidavit
party.
is still just
Yeah.
pristine.
Yeah.
All right. So we're not changing the statute, we're not changing the affidavit statute, but we're adding the cover sheet. Instructions to affiant.
Yeah, and then just certify in the affidavit that they agree to abide by it. And they read it.
Yeah, so that would change. So in section 7 of our statute, then we need to add a subsection, a statement that the affiant has read the instructions to affiant, and then refer to the statute that is that instructions.
Yeah.
And.
Yeah.
Has read and agrees to comply.
That's right, yeah.
Yeah,
Assuming that there are things to comply with in the instructions. Instructions may just
Who
be,
agrees to follow them.
Instructions, yeah, whatever,
or down by them or something like
Yeah,
that.
okay.
And that's just one line and it serves
Okay.
the purpose.
well, the instructions will include things like you have to let Rick know.
yeah.
You can't
Call Rick,
ignore-
just call Rick.
You can't
Put his
ignore your
personal
brother, you know,
phone
right?
Yeah.
He probably like that.
What's that?
Put his personal phone.
Yeah.
Oh, do it.
Yeah.
Then his email.
You can tell them what test
So
date.
there's nothing else
No,
changes, just the contents a little bit, we're gonna add that part, and then we're just gonna try to
Create
simplify.
an instruction sheet.
Yeah, and then
Instructions
it'll
to
add,
affiant.
Are we doing a form?
and then it'll add a.
Oh,
Like,
yeah, a statutory form. Yeah.
Anything's an improvement.
So who's doing the form? Are you doing the form too, Jennifer? You're doing the form and the instruction
I'm
sheet?
happy to do both. I mean,
Okay, all right, you got it. Just get it to Marisa.
Because then I can nag her.
well, I probably will show Heather.
That's fine. Do whatever you want to.
Yeah.
But let's get going on this. It's September, fall starts Sunday. We got a meeting next week.
Yep, 27th, 9:30 is when we did meetings. That's in the Capitol. I sent out the room
27th
yesterday.
in the capital.
So,
163 or something like that.
Yeah.
Marissa, would you have time to incorporate our, do a draft that includes the no asset, intermediate life amendments to what we've done.
The exit ramps.
For next week. Yeah.
Yeah.
Yeah. I think so.
Okay,
Yeah.
then that'll be a good
If you
meeting.
just send it to me before Thursday, I'll get it out to you.
And then we're gonna need, and then we'll see the forms, we'll need, I think, at least one more small group meeting. This is really helpful. At least one more small group meeting, I think, to tighten up the wrongful death business.
Does this room work for?
Oh, it's great room. Yeah.
We've got 111.
You guys have got to get your
Do we
work
wanna
in.
talk-
Come on.
Hey, you should see how much work it is.
I don't want a lot of work.
It is.
This group can't handle a lot of work.
Do we want to do a small group of people who?
Probably before we, yes,
procedurally
yeah.
are clued in, because on 111,
Procedure.
I'm gonna,
Yes, can you give that to us between, we have a meeting next week and then not
27th
until the
and
end of the
then-
month, right?
So let's see, no, because we moved, let me check what I sent yesterday.
Let's have a meeting on your work.
By the way, probate court is used by the courts and everything for any court.
So,
to do
yeah.
probate.
I know. We have.
Yeah.
So
we have
the
plenty
next-
of stuff.
And
Yeah.
the statutes, if you read them,
Yeah.
that way,
That's what it says.
it reads that
So-
way too.
Well, it's argued by litigators.
October
Technically-
11th.
I remember we fretted over that a few years ago.
I know we did, but if you look
Yeah,
at it
oh, okay,
closely, there is
okay.
not a single
And then we
statute
don't
that is
have one for a
specifically
while.
talking
Yeah.
about.
Yeah, but
11:30th, and then there's that
11th.
month we have nothing.
I'll show you.
let's
I think-
see if we can get a meeting of this group the first week in October.
First weekend.
I'll send it to
Yeah.
you, because I actually have.
To go
I actually
over
went through and I
Jennifer
itemized
and
it.
Heather's.
Right, I'll send out a
I'm
schedule.
gonna be gone October 3rd through 6th, so,
Oh, so we can-
so the second week would be, or
Well, the full group is meeting.
Full
the
group's the
11th.
11th.
Send out an email.
Yeah, I will. I'll do this after.
Yeah.
Okay,
I
so
just,
that's
I
the
usually
general
work from
statement
home on
that
Tuesdays, but I can make it Tuesday.
Yeah,
if
thank
I
you
have
for-
to.
All right, great work.
okay.
This is very good.
Those probably should.
I'm
be
starting to
starting
learn
meetings.
stuff a little bit. I have no experience in this area, but it's interesting.
It's a practical
The
solution
first
that
one
will be
is a general
acceptable by the
statement.
court.
I
That's
think
the
so.
two.
I think so.
Yeah, baby steps.
Baby steps.
Exactly.
So you'll have to see what we can do. Let him say.
Good sized baby steps.
Yeah, it's
Yeah.
a big improvement.
It is.
Well, and it's what some people are kind of currently doing with no authority.
Right.
So it's practical.
Yeah, yeah, we're
Yeah.
committing, we're amending statute to conform to practice.
Right.
Yeah, which is always a good thing.
Then all the changes are pretty logical.
They are, okay, all right, I'm good. So let's roll this out next
So what do you
week.
want to do with
Yeah.
wrongful
We have
death?
to say something.
I just want to look at them again. I mean, does everyone?
Yes, just whenever you get
Are we
distributed.
all
I'll
satisfied?
send it.
I'm not sure that. Oh, and also Shannon wants to have that.
Yeah, forgot the name of the attorney come.
Yeah,
Do
I
you know
want
which
that-
meeting I should invite them to? Maybe October 11th meeting?
No, probably the end of the month. She's the
Yeah,
latter
20.
half.
Those meetings were very interesting, but it struck me as the only ones who knew what they were.
I know,
talking about
which is
were
why I like-
Shannon and Brooks.
Which is why I'd like to spend a little more time on, so I know exactly what we've done.
Yeah, you haven't even really seen the final
No,
version
uh-uh,
of it.
no.
So,
So next meeting, let's go
Could
over,
Marissa and Shannon and Brooks polish that up.
well, you know, it could be a different small group, sure. And
And Jim-
I'll be
Jim-
involved.
Jim Hughley was the name of his.
Yeah, right, yeah, the Shannon wanted to bring, that's fine, different small group, because that
Yeah,
is
do a
focused
small
on,
group, you know.
on
All right,
wrongful death,
perfect.
sure.
So that would be,
Can I be a
that
part
would
of that
be.
too?
Yes,
And then the rest of us. is
Marissa,
gonna talk
Brian.
about-
so let's do a small group in the latter half of October before our October 30 meeting. So our agenda for next meeting will be
Yeah.
everything we've done this morning.
So
It'll
Marissa and
be
Brian, Shannon
the-
probably won't be able to come just based off what's
Right,
going on.
right.
is Shannon based in Portland or? Is she-
Yes.
She's
Oh.
in Portland.
I can meet them in Portland.
Yeah.
Shannon's
She's
is not,
having
not be able to
difficult
go.
Oh, is she? Oh,
Yeah,
no.
she's bed
Is she
rest.
bed rest?
Yeah.
Oh, no.
Yeah, it's not good. I mean, it's just for
And
her.
bed rest enough that she couldn't even call into.
Yeah,
So
yeah,
it's-
yeah,
Oh, that's too bad.
it is too bad.
I
So,
recorded
okay,
what
that's a
happened.
good point. You know, Shannon just having a real, Shannon, had a real difficult pregnancy. Yeah, she's on bed rest.